Please, my lord. Item number 1 has become infructuous, my lord.
All right. Dismiss as infractions. All right.
So,
For the two, my lord, no instruction.
No instructions dismissed.
No, I'm for OP 8. And
we've seen all these batch of petitions, Millards, either Millards by a writ petition or STRE Millards. Millards, the only question involved, Millards, is as to challenge to Section 2J, provision to Section 2J of the Orissa Income Tax Act, Millards. Millards, the last occasion, your Lordship was pleased to refer to the question involved in this case. And the mention of my friend that matter is pending for the Supreme Court, that's in a different context because that was only in the remedy relegated. So no stay, nothing. Your Lordship wanted to examine the issue involving challenge to provide your 2 minutes. That is how matter came up before Lordship Millards. Plus, the grievance of the petitioner is, whereas so far the provision to Section 2J of the Orissa Income Tax is concerned, whereas this is ultra-vires not only to constitutional provisions, but also very charging provision of Section 3 of the Orissa Income Tax Act itself, Millards. And apart from Section 3, Millards, it is also, Millards, it's ultra-vires to, Millards, entry 52, list to 7th schedule of the Constitution, Millards. 1. Article 14, 19(1)(g) and 301, Millards. These are the Millards constitutional provisions.
How long will this take?
This will take time, certainly, my lord, because
today we have a reference at 2 o'clock.
I understand, my lord.
it will take some time.
Millards, may I suggest at least 2 p.m. the way your lordship was taking up, that can help us to resolve this issue, Millards. 2 p.m. tomorrow, Millards, we are ready in the matter.
Not tomorrow.
Because everything is complete. Only one single issue is involved. Your lordship, Millards,
Correct.
Millards, to resolve the matter.
Yeah. Take a chance on 6th February, sir. 6th February.
6th February. 6th February. 5th, Millards. 6th February.
It's a Monday.
Oh, yeah. Huh? Interim order are
Wherever,
there.
yeah, wherever there are interim orders, those will cut.
Your Lordship, along with item number 3, item 30, item 33, item 34, 44, 56, 89.
Equal appearance.
All this.
It's one of the matters today I have entered appearance. That is, Millards, item 89, Millards. That may kindly be tagged up along with this 3.
All right.
Millards.
89 along with 3. Which are the numbers? You've noted down the numbers?
Your Lordship, I'm just giving.
In one of the matters, your lordship may permit me to file my wakalat now.
All right.
Connected matter.
Yes, yes. I'm giving number 3.
Item number 4. Item number 56, my lord, 2J matters, but the tribunal has remanded and the cell tax officer has...
Let me give the list openly, Your Lordship. Your Lordship may kindly note. Then Your Lordship, this my Lordship 3, item 3. Item 3, item 30, item 33, item 34, 44, 56, 89.
My lord, in 56, the tribunal has remanded the matter and the officer is pressing hard for reassessment. Your lordship may kindly stay operation of the tribunal order.
All right. In item 56, you say the impure order of the tribunal shall remain stayed till the next date.
Deeply would like, my lord.
Item number 4.
Number 4, my lord, I'm appearing through VC, my lord. I pray for a short adjournment, my lord. I have already prepared the date chart. Only for the note of argument, I will be taking a short adjournment.
At the request of Mr. Palayaprasan Mishra, senior advocate, who needs more time to prepare a note of arguments.
Come here.
22nd March.
I am for the opposite.
Mojo.
Item 5.
Item 5, my lord, I am on behalf of Mr. Kuresh Prasad Das. Kuresh Prasad Das is ill, my lord, so kindly taken up next week.
How much days delay? The MC 609, that's allowed. When you say the main appeal, you say counsel for the appellant is stated to be unwell. 27th March.
6.
Item 6, 7 and 8 and 8 to 18, 21, 22 and 23, that matter relates to trade certificate tax. The common, the appeal has been filed arising out of a common judgment. So in one case, your lordship directed to file affidavit stating directing the state to submit an affidavit as to what amount has been collected as excess under Section 5 of the Odisha Motor Vehicle Taxation Act. But today I have filed a small affidavit. I have already served the copy to the issue. And
My lord, if your lordship.
lordship also directed to file the affidavit by the appellants, and the appellants have also filed affidavit. Lordship gone to paragraph 3 of that affidavit.
My lord,
It has been stated that they have some of the dealers has collected from the trade certificate tax and fees from the purchasers, my lord, from the customers.
Which matters that affidavit been
No, my
filed?
lord, if I may,
Affidavit filed in WA number 180 of 2017.
my lord, may I be permitted? I have not filed the affidavit. I am filing it right away, my lord. I have given a copy, my lord. I have not filed it. I have just filed it. My lord, may I kindly have a glance at your lordship's order dated 12/10/2022, passed in WA number 223, which is one of the matters in item number 7. Item number 7, my lord, there are a batch of matters. WA2 Paradeep Motors
Yes.
is the matter where your lordship had passed an order on 12/10.
Right.
May I read out the order, my lord?
Yes.
My lord, your lordship directed the court would like the state to file an affidavit indicating clearly whether pursuant to the impugned letter instruction dated 29th March 2016 of the Transport Commissioner, what is being charged per vehicle sold is the additional fees in terms of Section 5. The court would also like an affidavit to be filed on behalf of the appellant whether the additional incidence of trade certificate in terms of Section 5 of OMBT Act and trade certificate fees in terms of Rule 81 of the Central Motor Vehicles Rule 1989 has been passed on to the customer and has in fact been paid by the customer. Both set of affidavits filed. My lord, here the Transport Department has only filed an affidavit which has just been served to your lordships, which has also been served to me, where the Transport Commissioner, on behalf of the Transport Commissioner, an affidavit has been filed only qua the transport tax, trade certificate tax. Whereas my lord had seen the demand made by them, one of the demands filed, wherein they had segregated trade certificate tax and trade certificate fees. And your lordship wanted to know that whether trade certificate is qua each vehicle sold or qua a vehicle that has been kept with the dealership at one point of time.
Yeah.
Now, my lord, my humble submission is the affidavit filed by my learned senior, my lord, only discusses the trade certificate tax. does not say anything. I only see the affidavit which my learned senior filed today. They are only quoting section 5 and have stated about trade certificate tax and nothing about fees at all.
Not one thing I would like to clarify, my lord.
Para 6, just see this.
Yes, my lord. Yes, my lord. No extra tax, my lord, I believe it says or fees has been collected beyond the tax provided under section 5. Now, my lord, may kindly see the demand that we had attached, my lord. My lord has the OADA because your lordship on last occasion had said that if there is an association, your lordship would like to take up that matter first. That is WA number 180. WA number 180, which is also there in section item 7, my lord. The third item.
Annexure 6 series.
Yes, my lord. Annexure 6 series. Now, my lord may kindly have a glance to any one of those 95 to 97, my lord. My lord, may kindly have Annexure 3 series first, 76 page number 76.
Yes.
Now, my lord, may kindly see page 76. If my lord may turn over the page and come to one of these trade certificates, which is at page 84, one of the demand notices. Page 84, my lord. My lord has page 84, my lord.
Yes.
This is a demand notice dated 10th February 2017. My lord sees it from the Regional Transport Officer, Jharsuguda.
So trade fee is separately shown, trade tax is separately shown.
Exactly, my lord. That is exactly what my lord had perused this and has said that if you are demanding trade the fees differently and trade tax differently, what is that amount and how are you? But in para 6, they are saying that not my lord may see para 6, they are saying nothing beyond section 5 is being collected.
Lord, may I pray, Lord, may I clarify one thing, Lord? The entire judgment of the Honorable Single Judge, Lord, relates to payment liability of trade certificate tax. So far as contention of my learned friend, with regard to levy of fees under Rule 81 of the CMB rules, a batch of writ petition has been pending before the Honorable Single Judge, and it has been listed now also. Lord, 200 writ petition is filed. That question has not been decided in that judgment. That is pending. So far as fees is concerned, under rule central motor vehicle rules.
No, but here also is agreed by the fees.
Not the demand.
Lord, that part has never argued before the learned.
What are you saying? Yeah, yes, last hearing, this was what was argued. I remember very distinctly. The argument was on both trade tax and trade fees. In fact, read our order, sir.
Yeah, I have.
Kindly read our order, sir. Point out whether we have mentioned trade fees.
Yes, but the court would like to state, like the state to file an affidavit indicating clearly whether pursuant to the impugned letter, instruction dated 23rd March 2016 of the Transport Commissioner, what is being charged for vehicles sold is the additional fee in terms of Section 5 of Odisha Motor Vehicle Taxation Act 1975. But that is the direction to the state.
Kindly read on, sir, please.
Court would like the state to file an affidavit indicating clearly whether pursuant to the...
So you are again reading the first sentence. I'm asking you to continue to read, sir. After the first sentence is one more sentence and there's another third sentence.
Sorry. The court would like an affidavit to be filed on behalf
would also like, sir. Kindly read carefully. We are not in a hurry.
Right.
You can read it carefully and slowly, sir.
Appellants, whether the additional incidence of trade certificate tax in terms of Section 5 of the OMBT Act and trade certificate fees in terms of Rule 81 of the Central Motor Vehicle Rules has been passed on to the customer and has in fact been paid by the customer.
So,
Mine.
just pausing here for a minute.
Mine.
You are not correct to say that in these matters, we are not concerned with the trade fees. This was argued. In fact, you were present. My memory serves me well.
Mine.
I don't know whether your memory serves you well. The argument was both on trade tax as well as trade fees. All right, which is why in our order, we have asked for both trade tax as well as trade fees.
Lordship may find that letter of the instruction issued by the Transport Commissioner, that is with regard to collection of trade certificate tax.
Not, sir. Let's come to Annexure 3 in that writ appeal 180. Your own demand notices, sir. I think every hearing you have to start afresh. All this was argued in your presence, and now you're pretending that you've not forgotten all of that. We are here to refresh your memory, sir.
Annexure 3 million.
That is our primary task, is to keep refreshing your memory.
Annexure 3.
In that Annexure 3 series, if you come to page 84, sir.
Yes, this is the demand notice issued by Regional Transport Officer Jharsuguda, and the demand. What it is?
Let's look at the subject matter, sir.
Short realization of differential fee and tax.
So two things.
Right.
What you are asking are two things. One is trade fee, the other is trade tax.
Right.
So you're not right in saying that in these matters, we're not concerned about trade fees.
But my submission is that so far as fees is concerned.
So you don't repeat yourself. Maybe 200 matters are pending before a single judge.
Right.
Does it mean that we do not decide what is before us?
Not.
And you're taken upon yourself not to answer?
But my humble submission is, as per the rules provided under the Central Motor Vehicles rules, the transport authorities have never collected any additional fees or tax from the dealers.
That question is not about additional, sir. What are you collecting is the question. And how are you collecting it? Under what authority are you collecting? That's all. Anyway, now that this is the affidavit they filed, why don't you carry on and complete the matter now?
Yes, my lord. No problem. My lord, may kindly, my lord, if I'll just try and refresh, my lord. The entire issue here, my lord,
Right.
is relating to trade certificate tax and trade certificate fees.
Correct.
Now, my lord, as your lordship had also asked that question, and these taxes fee very distinct from the registration tax that we paid, which is, my lord, 10% of the cost of the vehicle, or so on and so forth, depending on now, my lord, they have an escalating clause. Now, my lord, the entire issue, my lord, germinates from Section 39 of the MV Motor Vehicle Act, my lord. If your lordship has the act, it's also been quoted, my lord. It's also been quoted in the writ appeal, my lord. My lord, may kindly have page. I'll also quote it from that paragraph, my lord. My lord has page ground D.
Necessity for registration.
Exactly. My lord, may I quote that? Section 39 says, no person shall drive any motor vehicle and no owner of a motor vehicle shall cause or permit the vehicle to be driven in any public place or in any other place unless the vehicle is registered in accordance with this chapter and the certificate of registration of the vehicle has not been suspended or cancelled. What Section 39 says, ki any vehicle to ply on a public road, it needs a registration. That's the rule. Now, my lord, there is my humble submission is there is an exception provided to the rule. What is that exception, my lord? My lord, may kindly see Rule 33 of the CMV rules, which has also been quoted, my lord, at the very next page. Sorry, my lord, may I read that 39? I forgot the proviso, my lord. Provided that in page 10 itself, provided that nothing in this section, my lord has it?
Yes.
Shall apply to a motor vehicle in possession of a dealer subject to such condition as may be prescribed. So if it is in possession of a dealer, then the previous requirement of having it registered will not apply subject to the rules, my lord. Now, my lord, the rules itself, CMV rules, my lord, may have rule 33, which is, first, my lord, I'll take your lordship to rule 33, which is, my lord, has not been quoted, but I'll read it out from the book, my lord. My lord,
This is the central motor vehicle rule.
yes, my lord, central rules, my lord. 33. My lord has it, my lord.
What's the full title of the rules?
My lord, Central Motor Vehicle Rules 1989.
It has been quoted in the judgment itself.
Where which page? Which page?
Let paragraph 10, all the provisions under the act and the rules.
Para 10.
My lord, page 41 of your lordship brief. Page 41, yes, sir. 33 is page 42.
Correct.
Now, my lord, rule 33 of CMV rule says, my lord has it,
For the purpose.
condition for exemption from registration.
Right.
Right, my lord. For the purpose of the proviso to section 39, the proviso, my lord, we just read that if it's with the dealership, a motor vehicle in possession of a dealer shall be exempted from the necessity of registration, subject to the condition that he obtains a trade certificate from the registering authority having jurisdiction in the area in which the dealer has his place of business in accordance to the provision of this chapter. Now, my lord, 34 says trade certificate. Application for grant of renewal of trade certificate shall be made in Form 16 and shall be accompanied by the appropriate fees as specified in Rule 81. Separate application shall be made for each of the following classes, so on and so forth. Now, my lord, Rule 35 talks about grant or renewal of trade certificate. That may not be essential. My lord, may kindly have 39, the same. A trade registration mark and number shall not be used upon more than one vehicle at a time,
Right.
and upon any vehicle other than a vehicle bona fide in the possession of a dealer in course of his business, or any type of vehicle other than one for which the trade certificate is issued. Type of vehicle, Malon may kindly note. The trade certificate carried on a motor vehicle in a weatherproof circular folder, and the trade registration mark shall be exhibited in a conspicuous figure. No, my lord, if I pause here, my lord, what it says, 39 said every vehicle has to be registered. The provisos say if it's within a dealer, it may not be registered. But if you have to have a trade certificate. Now, my lord, trade certificate clearly says that an application shall be accompanied, separate fees. So, my lord, in 39, it says one particular trade certificate number, my lord, may be used with different vehicles, but not more than one vehicle at one point of time. But my humble submission is if I take trade certificate for 5 vehicles, my lord, and I am using, I may not have one vehicle, 20 vehicles, my lord. But if I'm plying it on the road, whichever vehicle I'm plying on the road, I will put that on that vehicle, use it, bring it back. Because my lord, trade certificate, my humble submission, is not connected with chassis number or engine number, which a registration is. My lord, a registration plate, once if we buy a vehicle, my lord, we get a registration plate number that is connected to a specific engine number and chassis number. But here it is not, man. 41. Purpose for which motor vehicle with trade certificate may be used. The holder of a trade certificate shall not use any vehicle in a public place under that certificate for any purpose other than the following. Number one, for test by or on behalf of the holder of a trade certificate during course or completion of construction or repair. B, proceeding or returning from a way bridge to a way, my lord. C, for a reasonable trial or demonstration by or any benefit of prospective purchaser. That means, my lord, when you give it for test rides, test drives. D, for proceeding or returning from the dealer or purchaser or any other dealer for the purpose of delivery. For proceeding or returning from a workshop with the objective of fitting body to the vehicle or painting or for repairs. For proceeding or returning from airport, railway station, wharf or being transported. For proceeding or to returning from an exhibition of a motor vehicle or any place, for removing the vehicle after it has been taken possession by or on behalf of a financer. So, my lord, my humble submission is Rule 41 of the central rules makes it very clear for what purpose a trade certificate can be used, my lord. Only for these purposes, which is, if I may add, my lord, for temporary use of a public place. My lord, has it, my lord? Now, my lord, after this, Rule 41, my lord. My lord, may kindly have Rule 81 of the CMV rules. That has not been quoted, my lord. I will just read it out, my lord. The only relevance of reading out clause 81 is, sorry, Rule 81 is, my lord. This says, my lord, we need the rules. Yeah. The central motor vehicle rules, not act. Let the act be here. Kindly get us rules. My lord, I have an extra copy. Excuse me, sir. Carry on. Rule 81 says fees, madam. Now, this is the trade certificate fees. My lord, may kindly see the fees which shall be charged under the provision of this chapter shall be specified in the table. The table below, my lord, may kindly see 1. Grant or renewal of trade certificate in respect of each class of vehicle. The fees is prescribed. So that under this section only, they are also charging for fees, my lord. Now, my lord, may kindly see now the provision under which they are charging tax, my lord, because tax is a local tax, my lord, fees is central. Now, my lord, tax is under a act called Odisha Motor Vehicle Taxation Act. It's quoted in page. Yes, my lord, that is quoted. Exactly, my lord. I bought it. That might see. That is at page 47, my lord, which is also quoted in the affidavit.
I think last time the controversy was whether you charge for all the vehicles
exactly,
one fee or you charge per vehicle.
Per vehicle, as in, my lord, my humble submission is because my lord saw Rule 41. Rule 41 says if a dealer is keeping, he only wants, he may be selling 200 vehicles over a course of a
so
year.
According to you, he must be asked to pay only once.
Once for one.
And not every time a vehicle is sold. They are saying every time a vehicle is sold, it means that particular vehicle could have been used for testing, could have been used for all these, and therefore you have to pay per vehicle.
I bought
that was the only controversy as far as I remember.
Yes. Also, another point which is in section 5 is at any point of time.
Yes.
It says at any point of time.
So they're saying every time you sell, you better pay this additional.
Exactly, my lord. So the demand that they're doing is violative of three things, my lord. Number one, Section 5 says it has to be an annual tax. Now, and in advance. So the way they are doing it, neither it is in advance nor it is annual, because you are collecting at the end, you are doing it for, my lord, in advance. You cannot ever imagine how much vehicle you will be.
What file have you passed it on to the customer or not?
Yes, my lord. So, my lord, in terms of your lordship's direction, my lord, we have filed an additional affidavit on behalf of the association. My lord, we have given a copy, my lord.
Kindly give me the copy. Yes.
No, my lord, because there are dealers and sub-dealers,
yes,
my lord, there was instances we came to know that some people have passed on and some people have not.
So this is again case by case, it has to go.
Exactly, my lord. That is the problem. But my lord, I just wanted to bring to your lordship an annexure 2 of that affidavit.
Yes.
On, my lord, which is at page 4.
So if you routinely pass it on to your customer, why are you complaining then? The customer is bearing it.
My lord, may kindly
some
see.
500 rupees per vehicle, right?
No,
what are they charging extra per vehicle?
That is what they are not yet clarifying, my lord, whether, because it's tax and fees. Because that's what they're, my lord, may kindly see annexure 2. Why we can't pass on? Because on 12/1/2022, after which I don't think, my lord, any dealer is doing it. My lord, may kindly see annexure 2. On 12/1/2022, the Transport Commissioner wrote a letter to all the RTOs saying alleged collection of excess amount. So they clarified that beyond these all things, you cannot charge.
Correct. That's different. So this is all within that.
No, my lord, this is not being included here. That is what I'm saying, my lord.
I don't know. We don't know that.
No, my lord, this is here, my lord. My lord, may kindly see. My lord, may see instructions were issued by office letter number this and letter number this on collection of excess amount over and above cost of the vehicle mentioned in the invoice from purchaser of a new vehicle and the procedure required to be followed by them. However, it is noticed that some of the dealers are charging extra amount from the purchaser of new vehicles over and above the cost of the vehicle and admissible taxes towards handling charges, registration expenses, charges for extended warranty, etc. Recently, the fees of registration of the vehicles payable by purchaser has been reduced from 282 to this under Commerce and Transport Department. However, some dealers are not passing on.
Else. They had reduced the...
well, that is on one part. Yes, ma'am. That is on the one
registration
part.
fee, they say...
Yes, ma'am. My lord, if I bow down, my lord, if we are allowed to pass it on, we have no problem. But they only time and again come up with circulars saying that, no, you cannot pass it on.
Over and above. And admissible taxes. Over and above the cost of vehicle and admissible taxes.
My lord, if the admissible taxes include trade certificate tax and fees, we have no problem. But only
how
they...
do you know it's not?
My lord, they
have not said that. They have not said that in their affidavit either.
My lord, here, my lord, may kindly see here, they have not mentioned the word trade certificate tax and fees.
No, admissible. They've used over and above the admissible.
Right.
Once under the trade certificate fee is an admissible fee, then what's your problem? You pass it on to your customer and that's the end of the matter.
Well, if on that...
obviously, they've said over and above what is admissible, you should not charge. That's all they say.
That fees prescribed under Rule 81 is a application fee. And that fee can be paid at the time of making application for trade certificate. So, Lordship may find Section 39 read with Rule 33. 33 provides whatever vehicle it is mandatory for a dealer to possess unregistered vehicle subject to obtain trade certificate. But 34 and 35, that is the procedure prescribed under the rules, how to make application and what is the fees that has been prescribed under Rule 81. So, what the dealers did, they have obtained for trade certificate in respect of 100 vehicles. And they have paid fees of 100 vehicles. Thereafter, they have repossessed more than 200 vehicles without any trade certificate. In order to avoid the tax and fee, it is mandatory. Your Lordship may Rule 33 may permitted to read again.
No, if he has finished, I'll allow you to argue. Let us find out if he's finished, sir.
So, my lord, my humble submission is two things, my lord. One, if we are allowed to pass it on, that's number one. But, my lord, the second issue, which is a legal issue, is it under law, is it permissible to take it for each vehicle and hence we pass vehicle? That's the question, my lord. That's the legal question.
They are. See, now there's been no stay of the judgment of the single judge.
Right, man.
and he has not agreed with you, he has dismissed your writ petitions, which means obviously you're passing it on. So you're not paying it out of your pocket.
No, not all vehicle, not all dealers. That's exactly what.
This affidavit is not categorical on that.
No, my lord, we have stated that some dealers have not collected it and some dealers have collected.
That's some and
I got it. My humble submission is
here.
Yes. My lord, my humble submission is under law. I mean, obviously, my lord, that's exactly why we are here before your lordship. The honorable single judge did not agree with us, my lord.
Correct.
But my point here is, my lord, under law,
yes,
it is not, my humble submission is not that on each vehicle they will ask.
Yeah.
If that be so, then I mean, then we'll pass it on for each vehicle. But that is not the law, my lord. My lord may kindly see, it is specifically stated that if at any given point of time it is you have 20 vehicles, then you take it for 20 vehicles. Now, my lord, there has been instances when they have done a raid, come and found out that you have taken trade certificate for 20 and you have kept 22 at one point of time, then they penalize us for 2 extra. But that cannot be said that you have taken for 20 and have sold 200. This has no correlation with selling. Humble submission, my lord. This trade certificate, my lord, has seen the provisions of the Central Act and the rules. Also the Odisha Motor Vehicle Taxation Act, my lord. There is no correlation that you sell it. If the vehicle is sold, then you pay for that. That is what the demand is. If that is being vindicated, my lord, then we probably, and it is allowed to collect, then we'll pass it on, my lord.
All right. Now you can start.
My lord. Yeah. The whole point is, my lord, whether it is for each vehicle or for the vehicle which the dealer keeps for the every time, that cannot exceed. Your lordship, I want to show your lordship, my lord. Yeah, first of all, my lord, the single judge went on a basis that the trade certificate tax, that section 5 tax has to be paid for each vehicle. That is not correct, my lord. Your lordship may kindly have a glance to Rule 7 of Odisha Motor Vehicle Taxation Rule 7. Though the learned single judge has taken note of that, but has not Rule 7 of Odisha Motor Vehicle Taxation Rules 1976, my lord.
Yes.
For the vehicle in respect of which no tax, additional tax is payable under Section 8, the declaration may be made in Form BB along with the document prescribed the notification in which the exemption of tax for vehicle has been notified, provided that no such declaration shall be filed or additional tax and tax token granted in respect of the vehicle which is declared off-road, provided further that the dealers or manufacturer paying tax under Section 5 shall submit declaration in plain paper stating legibly therein the category-wise make and model of the vehicle, number thereof. But this is very important. Maximum number thereof for which the tax, additional tax is being paid, and certify that the maximum number has never been exceeded at any point of time during the previous quarter, along with the trade certificate and the invoice. Dispatch note instead of such and such money. And to read, my lord, another provision I am showing your lordship, Odisha Motor Vehicle Rules, Rule 36. Odisha Motor Vehicle Rules, which says that the same thing, it is with regard to tax, that is Rule 36 with regard to trade certificate. Your lordship got it, Rule 36 of Odisha Motor Vehicles Rules, my lord.
Furnishing of return.
Odisha Motor Vehicles Rules 1993.
So the title is Furnishing of Return by the Manufacturer or Dealer.
Mal. The manufacturer or dealer shall furnish the registering authority having jurisdiction in the locality in the information in Form 13 and Form 14 in respect of the vehicle received in stock and sold by him during the every month by 15th of each succeeding month. The manufacturer or dealer shall furnish the copy of the sales certificate 21 prescribed under Rule 47 and the Central Motor Vehicle Rules 1989 to the registering authority of the concerned region where the vehicle is intended to be registered. Now your lordship may see the forms.
Form 14.
Form 14.
Yes.
Form 13 and 14. That is that what it says, what declaration, what they have to submit to the registering authority. This, my lord, these things, this tax is of 1975. And this was going on. And all of a sudden in 2016, they wake up and said that no, it is applicable for each vehicle. And the Form 13 clearly says, my lord, furnishing information in respect of the vehicle received in stock by the manufacturer dealer. And what are the columns? Serial number, date of receipt, number of unit received, number of invoice and date and remark. And Form 14 says, my lord, Form 14 they also said, and the last your lordship the certificate. The lordship kindly see the certificate appended to that Form 14. This is to certify that the maximum number of vehicle covered under the trade certificate has never been exceeded at any point of time. Had the legislation had the intention of collecting for each vehicle, they would not have said, it has to be paid in advance. The provision would not have been there at all. Yes, that provision would not have been there at all. And the Section 5 of the Orissa Motor Vehicle Taxation Act, my lord, clearly says that, my lord. Page 47 of the judgment that has been quoted, my lord, the Section 5.
Yes.
The tax payable by manufacturer dealer notwithstanding anything provisions contained in Section 3, 3A, 4, 4A, 4B. A tax at the annual rate. Tax at the annual rate specified below shall be paid in advance. Well, this is important, my lord. Paid in advance by manufacturer or dealer in motor vehicles in respect of the vehicle in his possession. In his possession, in course of his business at the or dealer under the authorized trade certificate granted to him by the Orissa Motor Vehicle rules. Now your lordship has to go to the trade certificate first. Under the trade certificate, whatever vehicle he has been allowed to keep. Suppose, my lord, I sell, my lord, 1,000 vehicles. That doesn't mean that I'll have to take trade certificate for 1,000 vehicles, my lord. I'll take 1,000 trade certificate for the vehicles which I have keeping stock for every month or every given time, every quarter, my lord. Suppose I am keeping a stock of 100 my vehicles, my lord. I certificate for 100 vehicles only, my lord. Because because it is the sale is being done, some vehicles also come to my lord, stock again, my lord. This process goes on, my lord. And your lordship may see Central Motor Vehicle Rule for what, and your lordship has to see the purpose for which the trade certificate is taken. Rule 41, my lord.
81, sir.
So rule 41 of that is fees. I'm talking about rule 41, purpose for which the trade certificate is taken. My lord. Trade certificate is not that unless I take trade certificate, I cannot do business. Trade certificate is taken for something else, my lord. The purpose for which motor vehicles with trade certificates may be used, my lord. The holder of a trade certificate shall not use the vehicle in a public place. This is why the trade certificate is being granted. My learned friend was showing Section 39, that is proviso to Section 39, that no unregistered vehicle shall be used on a vehicle, and the only rider is unless he has a certificate, my lord. And here, my lord, the purpose of trade certificate has been explained, my lord. The purpose of which motor vehicle with trade certificate may be used. The holder of a trade certificate shall not use any vehicle in a public place under the certificate for any purpose other than the following. For test.
No, but is anyone disputing all this? Who's disputing all this?
No question of disputing, my lord. No question of disputing, my lord.
Okay.
My only point of my endeavor is to, my lord, your lordship.
Everybody's endeavor is only that, sir. Don't charge per vehicle. If you've got 100 vehicles, you have to pay only one fee.
No, first your lordship has to.
There is a distinction between storage and sale.
That's right. So you are saying
trade certificate is only for
this is
storage.
only for the storage. And
Yes,
Not for sale. They are saying sale.
that is what has been argued even earlier, sir. That's the only point here.
Yes, that is the only point.
Right.
The problem is, now they say they are correlating this trade certificate for that. No, for each vehicle you are selling.
Correct.
Because tax we are paying. The person who is purchasing the vehicle is paying tax.
Correct.
Registration
My
tax.
only question last time was, if according to you, this is not payable per vehicle,
my lord,
are you actually spending it out of your pocket, or are you passing on this? When you raise a bill for the customer, he comes into your showroom, he wants to take out the vehicle.
It's out of pocket.
it is out of pocket, my lord.
Your affidavit does not. I gave you a chance to file an affidavit. I gave all of you a chance to file affidavits.
But my affidavit is ready. I have not filed, madam.
Whatever. That is up to you, sir. I can't compel you to do some things which you are not willing to do.
They are collecting after sale. So when the customer goes, they are demanding.
Sir, you're orally saying like this is one thing. Putting it down on an affidavit is another. All right. We have experience, sir. I don't know whether you have walked into a showroom to buy a car. I have. So when I sit down there, the man says, sir, you have to pay all this extra. I'm very desperate for my car. I pay him. Maybe you've not had that occasion to do that. In fact, he does that on a slip of paper. There are many things, many charges which the dealer in a showroom asks you to pay, which does not even come onto your bill.
If that is there illegally collecting, that is the domain of the transport authority. They should see that. If that is not collected, when I was standing counsel,
Mr. Pal,
I am giving an example.
Can I speak, Mr. Pal? With your kind permission, can I speak?
Yes. I was trying to give an example. What your lordship is trying to say was exactly happening here also, my lord. And in fact, for that, when I was standing counsel, we gave an instruction to all the dealers point to the registering authority that no extra charge can be collected from the dealer, person from who is purchasing the car. That doesn't mean they will, my lord, that cannot go against the statute. Statute doesn't permit them to take, my lord, for each vehicle. The charging section for the, my lord, fees, rule 81, that also for say the class of vehicle, not each vehicle. Confusion started where the rule 33 says class of vehicle, and the corresponding the charging section, fees charging section, that was for each vehicle, that was only amended in 2017. That created the problem, my lord. Earlier, the rule 81 says for each vehicle, and for that they started collecting. Now the rule 81 says it is for a class of vehicle, my lord.
Anyone else on this side? Anyone else wants to argue? A different.
Just one point. If your lordship will, that circular, that is annexed to my writ. Circular is there, my lords.
May I say, your lordship may give me some chance to file that affidavit. Your lordship may keep it to next.
We are not adjourning it any further, sir. We've given you time. Whatever is there on record, we'll take.
Last chance.
No, that's all right.
So we can file a.
We don't need to labor this.
No,
whatever you say, we have made a note of all that you're submitting. Yes.
Kindly see, my lord, that circular page 2.
Yes.
While reviewing the MB revenue collection of different RTOs,
right,
it is found that a tax being collected in advance from the dealers for the numbers of vehicles mentioning the trade certificate is not in conformity with the total number of registration of vehicle made by the dealers. This is the error. Error why, my lords? First is, my lords, it is not a tax. It is a fee for storage.
Right.
And for display and giving test drive. Second is, my lord, it has no nexus with registration of vehicle. When registration happens, I pay it under section 5 of the Act, 75 Act. You are therefore directed to collect tax from the dealers on the basis of number of vehicle possessed and registered. So they are merging two things, storage and registration, which is not what the Act says, 88(9) Act says.
All right. Just 2 lines of submissions, my lord. Just to supplement what my learned seniors referred to, my lord. Insofar as the storage part is concerned, my lord, the event of taxation is this, what we have described as fees, trade tax, etc. The other one is for registration. This is for your lordship to kindly consider. Insofar as that part, my lord, which your lordship questioned on filing the affidavit, etc., my lord. Here what happened was, my lord, the RTO, the officers of the RTO came upon the dealer agencies towards the end of the financial year and totaled up, my lord, saying you as a dealer had 200 vehicles which you could have held in terms of your trade certificate, but you've sold 2,000 vehicles. Hence, the differential into so much. That, my lord, is not possible to pass on to the consumer because the registration, etc., was already over. Had they checked that at the registration point, enforced, yes. Insofar as my humble submission is concerned, my lord, appearing for one of the, my lord, in item 7, that the event of taxation in both the fields, the scope is very different. Trade tax is for in situ holding the vehicle, my lord, coming from the manufacturer. Trade certificate granted. It's a temporary registration. Lordship will recollect, my lord, in the past, when we went to a dealer, my lord, he would put a red plate or a yellow plate and issue us the vehicle. Nowadays, the rule stands change. It must be registered at the event of the dealer. Without that, the dealer is not allowed to permit exit of the vehicle from the gate, my lord. Therefore, my humble submission will be the circular in the manner it's worded with the word and makes it contrary to law, my lord.
All right.
Hence, it needs to go.
All right.
That's my humble submission.
One more. There are also the petitioners here, the financiers. They are also charging the financer this, as per the trade certificate tax also there, the financer, they are also charging. The financer is not keeping any vehicle. He is only financing. They are saying the total number of vehicle you finance, you pay tax and you pay trade certificate. From where they got it, my lord, there is alien, are alien to the statute. And another one most important thing, my lord, let them clarify. Then, and also the statute says, my lord, it is advance tax, my lord. How can the person pay advance tax for the proposed sale he intend to make in a year, my lord? Now, had it been the intention of the legislation that it is for each vehicle, then tax has to pay at the end of the year, my lord. When it says the advance tax, my lord, and coupled with the section 33, 39, rule 36 of the Odisha Motor Vehicle Rules, rule 7 of the taxation rules, all says, my lord, the maximum number you are intended to keep, for that only you pay tax, not for the entire, my lord, entire sale you have caused, my lord. My lord, let him step there, we'll answer thereafter, my lord.
Item 22, first matter dealership. Here I am the manufacturer dealership. And I have not received their objection, my lord, that counter, my lord. Permit me, I can file this, my written notes of submission, dealership.
That you do.
But here the question is, my lord, I have a depot here to store. I am not selling. I'm just dispatching it to the dealers, my lord. But they are also charging me the same taxation, my lord. And whatever I am receiving stocking entire year, they are charging. I have taken for the numbers, my lord, what I am storing for a point of time, my lord. But they are charging me entire period, my lord. That is my dispute, my lord.
All right.
There are two things before your lordship. One is under section 5 of the Odisha Motor Vehicle Taxation Act, whether the dealer is liable to pay the tax as provided under the said section, by keeping the unregistered vehicle under the possession of the dealer. Well, lordship may find section 5 that has been quoted in the judgment. Once again.
Page 47.
Section 5 of the Odisha.
Internal page 16 of the judgment service.
That is
47.
Internal page 16 of the judgment.
You heard me correctly, sir. You heard me correctly.
Yes. Section 5 of the Motor Vehicle Taxation Act.
Yes.
Tax payable by manufacturers and dealers, notwithstanding the provision contained in section 3, 3A, 4, 4A, and 4B. A tax at annual rate specified below shall be paid in advance by a manufacturer or motor vehicles in respect of the vehicles in his possession in course of his business as such manufacturer or dealer under the authorization of trade certificate granted under the motor vehicles rules. But here, it is a charging section. The whatever number of vehicles under possession of the dealer, the tax as specified in the table, the dealer is liable to pay. Then question comes, your lordship, my learned friend has submitted the section 39. That is in order to avoid the rigor, that no person can drive a unregistered vehicle in any public place. That provision is not applicable to the dealer, subject to he obtains a trade certificate. Section 39 of the Motor Vehicles Act has been quoted.
You've abandoned now 5. You do not want to read anything more. In section 5, you do not want to read anything more, sir.
What I want to submit, my lord, in that section, it is possession is important for levy of.
Question, sir. You stopped reading section 5 at a certain point. Do you don't want to read anything more?
Yes, my lord, that for motorcycle that has been prescribed under that rule. The fees has been prescribed.
It's all right. He does not understand. He does.
Yes, my lord.
We cannot compel you to understand something that's passing in our mind.
I am reading.
It's up to you.
I am reading. Sorry, my lord. I am reading. I am reading. One, the motorcycle, where the total number of vehicles does not exceed.
We are not dealing with motorcycle now. I mean, whatever.
That annual rate of tax has been provided in the table.
You're missing out the main argument. This is up to you. See, we sit and listen to all their arguments, right? We understand their arguments in a certain way. We think you are also listening to their arguments. So we also presume that you will answer what they're trying to argue. So it is up to you.
My argument confined to only two possession, confined to section 5 of the Odisha Motor Vehicle Tax.
What is their main argument, sir?
They have argued which has not been provided under the Act and the rules.
What is their main answer?
They have argued that at a given point of time, they have possessed a certain number of vehicles and the tax has to be collected in advance. At the end of the year, the regional transport authority or taxing officer shall not have jurisdiction to collect the advance tax.
This is their argument?
Yes.
No other argument?
Yes, that is the argument.
They'll all be very unhappy today, sir. They think they're arguing so much for so long and they presume that you've understood what they are arguing.
That they have argued that is not provided. That is why.
Is this the only argument they have done?
No, my lord, unless lordship gone through the statute, it may not be clear, my lord.
To whom?
Their argument may not change the statute, my lord.
No. What is their argument?
Yes, my lord, it is very clear under the statute. Section 5 is there.
Carry on. Sorry to be interrupting you like this. We are deeply apologetic, sir. We seem to have stopped your line of thought.
I am also sorry. I am not supposed to answer.
No, you're not supposed to answer. You're correct. Yeah, you're not supposed to answer their argument.
I am only on the law.
Yes.
The statute provides.
See, new ways of approaching litigation in court. When I was a lawyer, if I was appealing for the respondent, I will try and answer what the petitioners argued. You're saying as a respondent, I don't have to answer what they have argued.
What they have contended is not under the Act and the rules.
All right. Carry on.
Section 39 of the Motor Vehicles Act again.
Yes.
Lord, necessity for a registration. No person shall drive any.
You first make your proposition, because we have read this quite often now in the course of these hearing of these matters.
Here, my lord, there is a.
First, make your proposition.
My proposition is there is a clear bar to operate a unregistered vehicle in any public place.
Correct.
Lord, without registration.
Very correct, sir.
But that proviso provided,
Yes.
that provision of section 39
Yes.
will not apply to the dealers.
Correct.
Subject to, my lord, rules.
Correct.
That rules prescribed under Rule 33.
Right.
My lord, what are the rules? Well, Lordship, kindly see Rule 33.
Right.
Now, Rule 33 provides
The purposes for which they will hold.
is
That he has read.
conditions, my lord, conditions for exemption from registration.
All right.
My lord, for the purpose of proviso to section 39,
Right.
a motor vehicle in possession of a dealer or manufacturer of motor vehicles or automobile ancillaries or a test agency specified in Rule 126 shall be exempted from the necessity of registration, subject to the condition that he obtains a trade certificate from the registering authority having jurisdiction in which the dealer or manufacturer of automobiles or automobile ancillaries or test agencies specified in Rule 126 has his place of business in accordance with the provisions of this chapter. So exemption is only granted to possess a unregistered vehicle subject to he obtains a trade certificate. My lord, 34, my lord, Lordship, kindly see 34, Rule 34.
Yes.
An application for grant or renewal of a trade certificate shall be made in Form 16 and shall be accompanied by the appropriate fees prescribed in Rule 81.
Right.
So the fees prescribed under Rule 81 is the application fee for obtaining a trade certificate.
Right.
For making an application,
Right.
that application must be accompanied with the fees prescribed under Rule 81. So, my lord, from the reading of section 39 and Rule 33, it is mandatory for the dealers to keep possession of unregistered vehicle subject to obtain the trade certificate. The dispute is, my lord, what the dealer did, the dealer makes application for 10 vehicles for possession. Accordingly, he has made application for a trade certificate by giving fees for 10 vehicles before the registering authority. My lord, that certificate has been granted, and the dealer has also, my lord, paid tax under section 5 of the Taxation Act for that 10 vehicles. My lord, what the dealer did, my lord, after sale of that 10 vehicles, my lord, keeping hundreds of vehicles without authority or
How do you know
without
that, sir? You don't even know that.
My lord.
How do you know that?
My lord, so, my lord, they have not submitted the report as provided under.
How do you know? How do you know they have hundreds of
They
vehicles?
have sent for registration to the registering authority.
So that because they're selling. When they have to sell,
Yes,
their vehicle has to be
yes,
registered.
that is why the Honorable Single Judge has said that unless the vehicle under possession of the dealer, the same cannot be sold to customer.
So for every vehicle possessed, you don't have to pay this fee, sir. That's why you did not read the remaining part of 39. 39 permits you to possess a certain number of vehicles. Not that you don't pay the fee for every vehicle.
Yes, that is Rule 33.
Not for every vehicle, sir.
That is
This is for possessing vehicles, not for possessing every vehicle.
That, Lordship.
A dealer can't, no dealer will have a whole showroom for one vehicle, sir.
No, whatever
No
number.
dealer will take a storage space for just one vehicle.
That is why the whatever number the dealer wants to keep.
The whole idea of storage is that you have to store many vehicles, correct?
Yes, my lord. What provided he has to obtain a trade certificate.
Who's saying,
for all the
they are
vehicles.
also not arguing. They're argue not take a trade certificate? Where do they argue that?
Well, they have trade certificate only for few vehicles.
What is that few? What is your understanding of few?
Few means, Lordship, they have obtained trade certificate for 10 vehicles. They have paid fees for 10 vehicles.
Yes.
And paid a tax for 10 vehicles.
Correct. You agree that?
Yes. Ma'am.
Then
Well,
why are you now insisting they should pay for every vehicle then?
Milord, if the trade certificate has been granted for 10 vehicles and the tax has been paid for 10 vehicles, Milord, if any more vehicles, Milord, than the 10 vehicles,
How do you know that, sir? That's what they're asking you.
Milord,
How do you know they kept more than 10 vehicles? They kept more than 10 vehicles. How do you know that?
Milord, they have sent the registration for a registration, Milord.
Anyway,
After
this is back to square one.
All right, that has been discussed, Milord, here.
All right. Anything else, sir? Anything else?
One point. My lord, admittedly the 75 Act and this Central Motor Vehicle Act is 88. Now kindly see 7th schedule.
Yes.
The state list.
Constitution. So the third book in the top. Yes.
7th schedule, state list 2, entry 57.
Yes. Yes.
57. Taxes on vehicles, whether mechanically propelled or not, suitable for use on road, tram car, subject to the provisions of entry 35 or list 3. Now kindly list 3, entry 35. This is the power exercised by the Parliament for the 88 Act.
Correct.
So that state 75 Act will be subject to. So once the 88 Act says fees, you cannot exercise 5.
Or
Grateful.
or orders reserved.
Grateful.
One thing more, I just wanted to, my lord, the mode of use of the trade certificate, may I that apprise that those sections? My lord, section 39 of the Central Motor Vehicle Rules clearly says how the trade certificate, use of trade certificate mark and number. A trade registration mark and number shall not be used upon a vehicle, upon more than one vehicle at a time, or upon any vehicle other than the vehicle bona fide possession of the dealer, manufacturer, automobile ancillaries, test such and such in course of his business on the type of vehicle other than one of the trade certificate issued. And the trade certificate carried on a motor vehicle in a weatherproof circular holder, and the trade registration mark shall be exhibited to the conspicuous place of the vehicle. This is only for the facilitating the purpose for which the trade certificate is been issued, not anything else, my lord. The section 40 says, as rule 40 says, restriction on use of trade certificate or trade registration mark number. A trade certificate shall be used only by a person to whom it is issued. Such person shall allow or offer or cause certificate registration assigned in connection thereto shall be used by any other person, provided that the provisions of this rule shall not apply where a person to whom certificate is granted or such and such not required, my lord. And the more important is, my lord, we are, my lord, some of the petitioners are the, my lord, here are financiers, my lord. What are the use of the trade certificate for financer, my lord? The financer has only one use, 41H. For removing the vehicle after it has been taken possession or on behalf of the financer due to any default on the part of the other party under the provisions of the agreement of the hire purchase and lease and hypothecation, my lord. The financer doesn't keep any for, my lord, for selling, my lord. They are also charging the financer the section 5 tax, my lord, and also saying that you pay for all the vehicles.
My lord, may I give a list of all other matters which have been listed today as well, my lord?
Yes.
My lord, shall I just write it in a paper?
Yes.
My lord.
Reserved in all those matters.
My lord, which are all on the similar matter. I'll just write it in a piece.
Will be permitted to file a note of submission.
All right. So parties are permitted to file a written note of arguments within a week.
Grateful, my lord.
All right.
And on 9,
Eight is with 7, is it?
yes.
It is the same.
6, 7, 8. 6, 7, 8.
Some other matter.
21, 22, 23.
Sir, which matters are covered, he will know.
My lord.
In this batch,
My lord.
which are the items in the list in this batch, sir?
Yes, my lord.
Which items are included?
My lord, item 6, 7, 8 to 18. 8 to 18, my lord.
Ah,
Then 21, 22 and 23.
all right. All right.
Two retapils also I have filed, that is also covered. By the,
Which number, sir?
that's, 1 second, balance. I'm just.
WA 250 of 2017 and
That is there.
2017.
That is there in the batch.
They are in the batch.
Yes.
If they're in the batch, then don't need to mention it, sir.
Obliged.
No, sir.
No. Okay. Item 19.
From 8 to 18, he said.
18, sir. 18, sir. 18, 21 and 22. 19. Item 19.
None appears dismissed.
20.
May I please alert? A short list of dates, my lord. This retapel has been filed challenging the order dated 6/12/2017.
Kindly, sir.
My lord. Annexure 3, page 108, my lord.
Yes.
The order passed by the Honorable Single Judge, my lord.
Yes.
This is it, my lord. And wherein the Honorable Single Judge had taken care of the judgment passed by this Honorable Court, in where it has been by this Honorable Court that the caste certificate is not necessary for a person to residence certificate is not necessary for a person to apply for the Shiksha Sahayak in a particular area, my lord.
Residence certificate is not necessary.
For a particular area. If he belongs to Moribund district, he can apply in any district inside Odisha for Shiksha Sahayak, my lord.
I see.
My lord, my lord, here the case of the petitioner is that, my lord, the petitioner initially belongs to Uddola, my lord, and in the district of Moribund. She has applied for the post of Shiksha Sahayak.
So what is the reason why the court did not interfere? That you're not telling us?
Because the caste certificate has been cancelled, my lord.
I don't know whether we're reading the same order. I'm reading an order at page 110. Is that the same order, sir?
612.
Yes, my lord.
It's the same order.
It starts from 108, my lord.
The order is at page 110.
Yes, my lord.
But I don't know, when I read it, something else seems to be the issue. You read it, sir.
My lord. Considering the submission of learned counsel for the petitioner after going through the pleadings made in the writ petition, it appears the main dispute revolved around non-considered of the case of the petitioner pursuant advertisement under Annexure 6, even though the petitioner has been allowed to continue on entertaining the writ petition, but there is no order staying giving effect to advertisement involving Annexure 6 Annexure 6 must have been given effect to since 2006 for no interim order staying the operation of advertisement by the Annexure 6. This court is not in a position to interfere in the advertisement under Annexure 6. There is also no amendment of the writ petition involving the development pursuant to advertisement by the Annexure 6, leaving no scope for to entertain such writ petition.
So where is this our point about residence certificate and all? The single judge seems to have dismissed your writ petition, saying this is a 2006 advertisement against which there was no stay. And therefore, in 2017, I do not want to interfere with the.
I am coming to that.
You are coming to it after we are pointing out to you. This is the main point on which the writ petition is dismissed.
Your Lordship may kindly see the next paragraph of the same order. So far as the challenge to the order of the collector is concerned, for the decision of this court reported in case of Chandrajana and others, State of Odisha and others, 104/2007 CLT 613. There is no requirement for consideration of residential aspect of the candidates involving appointment of Swechasevi Shiksha Sahayak.
This is another point, sir.
There is a prayer, twofold of prayer of the petitioner in the writ petition. Your Lordship may see the prayer of the prayer in the writ petition. Your Lordship may see the prayer, my Lord. Thereafter. Page 30 of the writ petition, my Lord. Writ appeal, my Lord.
Yes, please. Continue.
In view of the circumstances of the case, the petitioner respectfully prays that this honorable court may graciously please to admit this writ petition and issue a rule calling upon the opposite party to show cause as to why the order of the Tahsildar dated 28/3/2007 and 24/2007 under Annexure 1 and the order of the collector under Annexure 11 ought not to be quashed / set aside, and failing to file show cause or file insufficient cause make the said rules receive absolute, and may issue a writ in the nature of mandamus directing the opposite party to include her name in the final selection list under Annexure 9 in the interest of justice, my Lord. Well, your Lordship, this honorable court has passed an interim order on, my Lord, I have reflected in the dead chat, my Lord. (28/3/8/2007) for stay operation of Annexure 1 and 11, my Lord. 8/11/2007, sorry, my Lord. 8/11/2007. Annexure 1 is the the petitioner application has not been considered due to the report of the Tahsildar without the residential certificate. He has issued the issued a clarification stating that at the time of issuance of residence certificate, the petitioner was unmarried, and after that she got married in Balasore district. For that reason, her name is not included in the final selection list, my Lord. Though her name has been included in the select list, at the time of preparation of final select list, that has not been included.
No, what is the effect of stay of that order?
My Lord, Annexure 1 is the order passed by the Tahsildar, my Lord. And thereafter, they have allowed the petitioner to continue because initially the petitioner was appointed in the year 2003 as Shiksha Sahayak. This honorable court was the entire selection for the state and allowed the persons, those who have got selected in for the year 2003 and 4 to participate in the next selection process, my Lord. For that reason, the petitioner participated in the selection process in the year 2006 and her name took place in the select list, but in the final merit list, due to the letter issued by the Tahsildar, her name did not took place. Thereafter, she approached this honorable court. This honorable court directed the collector Moribund to take a decision in the matter, and the collector Moribund by the Annexure 11, my Lord, has rejected the prayer of the petitioner.
How are you saying that, sir? In the select list, your name did not find place on 7/4/2000 dates.
My Lord,
in your own
final select list, my Lord.
So you did not get selected.
My Lord, your Lordship may see that is That is in the record, my lord. The
I'm
select-
asking you a question.
Yes, my
You
lord.
say in 7-4 in your list of dates,
Yes, my lord.
serial number 13.
Yes, my lord.
You say you are not selected.
Final merit list for B.Ed candidates has been published, my lord. But my lord, thereafter,
No. In that list, your name did not find
my lord,
place.
your lordship, serial number 10, your lordship.
No, but right now we are beyond that serial number 10, right?
My lord, your lordship, for a moment, serial number 10, 1/12/2006.
Yes.
The provisional select list of B.Ed candidates was published for appointment of Shiksha Sayak under Udalabak. The name of the petitioner took place in serial number 3, my lord.
But in the final list, your name
Because
is not there.
due to the action of the Tahsildar.
Whatever search,
my
you
lord.
are not working as Sikya Sahayak. You are trying to submit that you are working continuously as Sikya
My
Sahayak.
lord, they have not terminated me because I got this job in the year 2003 by virtue of this honorable court's order. They have only terminated me in the 2018 after disposal of the writ petition, my lord.
You are extraordinary, sir. You're such a benevolent state. The entire selection was cancelled by this court. You allowed her to continue.
No, my lord, the earlier selection which was made in the 2003.
The entire selection is cancelled way back in 2004. You allowed her to continue for 14 years. She never got selected.
No, that part I don't have.
That's what he's saying. Despite the selection having cancelled in 2004,
yes.
her not succeeding in the subsequent selection, she continues. I know this is extraordinary.
In some cases, that pursuant to that, after passing of that process of 2003, in some cases, by virtue of the order of the authority, they were allowed with an intention that to give them opportunity to participate in the subsequent selection process.
So they'll continue.
But subsequently,
once a court has cancelled all appointments, you will allow them to continue.
No. They were allowed to participate in the subsequent selection.
No, he was allowed to continue,
but
sir.
Here, yes. Just now I am taking note of that. Lordship, I can take instructions.
You better take instructions. This is extraordinary. Which means you're paying salary to a person whose appointment has been cancelled by the court.
No, my lord, they were under...
and never selected. Just see, for 14 years, cancelled in 2004, never selected after that, but merrily continuing till 2018. And drawing salary also. It's extraordinary. Despite losing the writ petition also, continuing.
So, after dismissal of the writ petition, as he is submitting, that after dismissal of the writ petition, she was terminated. It is his submission. That after the dismissal of the writ petition under page 110 of the present writ appeal, she was been terminated. But that since there is no such information with me, I cannot give a concrete.
So right now you're working or you're not working?
No.
Fortunately, right now you're not working.
Unfortunately, my lord, I will say because the order passed by the collector is annexure 11 that has been stayed by this honorable court, my lord.
All right.
My lord, the Tahsildar has passed an illegal order. Though I belongs to that area. And I am till now I am residing in that area also. For the act of the Tahsildar, which is beyond his jurisdiction, my lord, he has submitted a report which is not correct, my lord. The RI has given a report stating that I am residing in that area after marriage also. And without taking the note of those things, the collector has passed the order under annexure 11, my lord. Where all the facts has been taken care relating to selection of the petitioner as a Shiksha Sayak.
What is your case, sir? On merits, what is your case?
My lord.
So kindly state your case on merits.
The case of the state, after the selection was passed in the 2003, by virtue of the opportunity given to them in the judgment itself, that they will be allowed to participate in the subsequent selection process. And the subsequent selection process, she participated, and so her name was not found place as in the final merit list on the ground that of residential certificate. And that she has challenged before this honorable court. And this honorable, by the time the writ petition was disposed of, the selection process in which she has participated, that was already been over. And the persons who were found suitable, they were already given the appointment, engagement. And now, at present situation, there is no Swechhasayaka is not there in existence because of the closure of the scheme. Because now the scheme, that is a scheme introduced by the government of India, funded by the government of India, duly implemented by the state. State of Odisha will only required to only implement the centrally sponsored scheme. And subsequently, government of Odisha's formulated scheme, instead of going for a direct recruitment for primary school teachers, the government of India, state of government has taken a policy decision that from among the working Swechhasevi Shiksha Sahayaka having the training qualification and with certain experience, the government of state government will have to observe them as regular primary school teachers. The moment they were observed as primary school teachers, they became the government of the employee of the state government. But the Shiksha Karmis who were Swechhasevi Shiksha Sahayaka, they were initially their engagement is under the central sponsored scheme funded by the government of India. Only the state government is required to implement the scheme. And that in that process, there was certain irregularity found in 2003 that by virtue of a simply later, there was engagement of more than 9,000 Shiksha and which was challenged in case of that Hussika Smidhani, and that has been quashed in holding that the entire or engagement of the Swechhasevi Shiksha Sahayaka pursuant to that letter are null and void. So thereafter, in order to allow them to participate in the subsequent selection process, they were somewhere they was allowed to continue till their next selection process is over. But here is something exception. I am finding that she allowed to continue for such long time. But in fact, she was not found in the list, so accordingly selection process was over.
So unfortunately, you also don't come to the main point, sir.
That residential.
Every time we have to read ourselves all the pleadings to find out what the main point in the case is. He does not say what the main point is. You do not say what the main point is.
No,
the main point is the residential certificate. She got married. So they said since she's married, she's not residing in that same place. Which is why her candidature could not be confirmed, which is why she was not selected. That's the main point, sir. Residential certificate is the main point.
I know, but I am not.
You know, you are keeping it to yourself, so you're not sharing it with us.
I'm not coming to that point.
Why you are not coming to that point when we are asking
because of the decision of this honorable court, I'm not taking a different view because that Chandramani Jana case, this honorable court has laid down the principle that the residential certificate, residential status has to not be
necessary.
I have given the judgment.
That's why I'm not coming to that point.
How does it help? That is the point. So then if the residential certificate is not necessary, then how could her candidature not be accepted?
That one, there was no, since there was no counter in the original deed instruction, I cannot apprise your lordship the correct position.
So because she was not found resident there after marriage, they said she is not a resident. So now this whole scheme is gone.
Yes, ma'am.
Then you can't be appointed again as that.
And she is now must be 47 or 48.
Swechhasevi Shiksha Sahayak. You cannot be appointed as that. The whole scheme is over.
Those persons has got the selection at that point of time. They are not the regular teachers, my lord. For no fault of the petitioner has suffered a lot, ma'am.
What to do,
and
sir?
now
We can't
going
give
to suffer a lot, my lord, because
he has
approached this honorable court in time, my lord. If at all he has not approached this honorable court, and this honorable court has been pleased to pass an interim order by staying the order passed by the collector. Collector has passed the order taking into consideration the guideline and also the selection process which was done by the authority relating to selection of the petitioner as the Shiksha Sahayak, my lord. and collector has hold that this at that point of time he is not residing at his native place, because by that time she has married and she has submitted the certificate before that also, my lord. So there is no fault on the part of the petitioner. And when the writ petition was filed, by that time that judgment was not there. After 10 days, that judgment has come, my lord, which is reflected in the rejoinder affidavit by the petitioner also, after filing of the counter by the...
No, but today there's no such post. So even if your writ appeal is allowed, it will only mean that you get reinstated as Sikya Sahayak. There's no post. How can you get reinstated?
Because I have been allowed to continue in this.
Only to 18.
Because I have completed 6 years of service. For that reason, my similarly situated persons, those who have got selection at that point, they are appointed as the...
Maybe you can apply for
regular teacher.
I don't know how you can apply now. For
I did not apply afresh, my lord. Because already they have got the job of teacher, my lord.
You've been out of it, sir. You've been out of it since 2018.
My lord, because
2017 actually. 2017.
In 2018, I got information of extended night, my lord. She has
January 2018.
2018.
That's virtually.
She has been terminated.
5 years now.
She has been terminated.
Once you're out of the system, sir, there's no question of asking you to be considered
and
for
if it is done illegally and without following law, then your lordship
you can sue them for damages.
Your lordship has ample power to restore the
not such ample power, sir. That much power and all we do not have. Under Article 142, Supreme Court has.
Your lordship,
no question. When a post itself is abolished, we do not have that power.
It is up to your lordship. I am submitted.
All right. You see, the challenge the
petitioner is going to suffer.
Is to an order dated 6th December 2017, passed by the learned single judge, dismissing the appellant's writ petition civil 10408 of 2007. Paragraph. The background facts are that the petitioner was initially appointed as Svecha Sevi Sikya Sahayak, and an engagement issued in her favor on 10th February 2004. Paragraph. Subsequently, in writ petition civil 11748 of 2003, this court delivered a judgment dated 29th April 2004, quashing the entire selection of 4 SSS, which Svecha Sevi Sikya Sahayak bracket 4 SSS in the entire state. Full stop. A chance was granted to the selected candidates to apply afresh and for being given additional marks at the time of their selection. Paragraph. Thereafter, on 20th September 2004, the appellant again applied to the Tahsildar Udala for issuance of a residential certificate in her favor. Full stop. Pursuant thereto, on 23rd September 2004, the Tahsildar is said to have issued such a certificate that the appellant was a native of the and that her family ordinarily resided in village Mauda under the Udala Tahsil. Paragraph. On 13 June 2005, the appellant was married to a resident in the district Balashwar. Full stop. In October 2006, a fresh advertisement was issued for selection and appointment of SS in the state as per block/unit wise. Full stop. Pursuant thereto, on 27th October 2006, the appellant submitted her application, enclosing the necessary documents. Full stop. In the provisional list of selected candidates published on 1st December 2006, the name of the appellant was at serial number 3. Full stop. Paragraph. However, when the residential certificate was sent for verification, a report was submitted that it was not genuine. After marriage, the appellant was no longer residing at the original address given in the certificate. Full stop. In the final list that was published, the final list of selected candidates of SS published on 7th April 2007, the appellant's name did not figure. Paragraph. When the appellant appeared before the Tahsildar, what was called for from the RS. What is RS?
Revenue supervisor.
So revenue supervisor bracket RS Kapti Pada. Although a report was submitted that she was staying in a rented house at Kapti Pada, the Tahsildar Udala on 20th April 2007 issued an order holding that the residential status of the appellant was more. Stop. At that stage, the appellant filed writ petition civil number 5777 of 2007, which was disposed of with this court on 9th May 2007, permitting the appellant to submit a representation before the collector Mayurbanj, which was to be considered within 2 months. Paragraph. The collector rejected such representation on 4 July 2017, only on the ground that the appellant was not a resident of village after her marriage. Paragraph. The appellant then again filed writ petition civil 10408 of 2007, challenging the order of the collector, as well as the order passed by the Tahsildar Udala on 20th April 2007. Paragraph. On 23rd August 2007, a judgment was delivered by this court in Chandramani Jaina versus State of Orissa, 104 bracket 2007 bracket CLT 613, stating for the post of SSSS, the requirement of a resident certificate showing the candidate to be a resident of the particular area where the appointment was going to be made was not required. Stop. In other words, as far as the present appellant was concerned, the fact that she no longer was a permanent resident of village Mauda would not come in the way of her being appointed as SSSS. Paragraph. An interim order was passed in the writ petition staying the order of the Tahsildar and the collector. Full stop. As a result, the appellant continued as SS throughout till the dismissal of her writ petition by the learned single judge on 6th December 2017. Full stop. She appears to have been actually relieved from service sometime in January 2018. Paragraph. While it is true, as submitted by learned counsel for the appellant, that as a result of the judgment of this court in Chandramani Jaina, Supra, the disqualification of the appellant for being selected as SSSS is no longer valid. The fact remains that the post itself now stands abolished. Full stop. Counsel for the state informed the court that this was a scheme sponsored by the central government and implemented by the state government, and the scheme itself has come to an end. Full stop. Those who were serving as SSSS were subsequently absorbed in the regular teachers in the state government. Full stop. However, as far as the appellant is concerned, by virtue of the dismissal of her writ petition by the learned single judge, she did not continue after January 2018. Full stop. Paragraph. The net effect is that today the court is not in a position to issue any mandate to the respondent state to reinstate the appellant as an SSSS, without which the question of considering her case for regularization, for being appointed as a regular teacher, does not arise. Paragraph. Counsel for the appellant urged that the appellant was out of service for no fault of hers, and therefore This court should, in exercise of its powers under Article 226, direct her absorption in the state government. Full stop. Paragraph. The subsequent events have made it not feasible for this court to issue any such mandamus as prayed for by the appellant. Full stop. In other words, when the post of SSSS is no longer available, it is not possible for this court, while setting aside the impugned order of the single judge, direct the appellant's reinstatement as SSSS. Full stop. Unless that status of the appellant is restored, the question of her being considered for regularization, for being regularly appointed as a teacher in the state government, does not arise. Paragraph. It will nevertheless be open to the appellant to seek compensation, to seek other appropriate remedies for compensating her loss as a result of the action of the state government. Full stop. Consequently, while holding that the impugned order of the single judge does not reflect the correct legal position as far as the petitioners, that appellant's engagement as SSSS is concerned, the court is not in a position to grant any further relief to the appellant by virtue of the subsequent developments. The appeal is accordingly disposed of.
And on 24.
From 24, this appeal of the state, there is a delay of 243 days.
So the delay of 243 days is not properly explained. Consequently, the court is not inclined to condone it.
And otherwise, the issue
number 110 of 2019 is accordingly dismissed. Nevertheless, the question of law is left open for decision in some other appropriate case. The writ appeal is accordingly dismissed.
25.
Item 25 on behalf of JSGML, let it come next week, heat of station. In the meantime, we will remove the defects, madam.
Let's it's since 2019.
What's the delay, sir? Let's see the delay.
Well, delay only 40 days. 40 days delay.
And not pursued flats.
No, due to change of panel, my lord, we have not the file. We have
40 days, all right.
40 days.
What's the matter about? What's the matter about, sir?
The learned single judge has allowed the impugned order under annexure 15 and 18. Against the disciplinary proceeding initiated by the competent authority, my lord. The disciplinary proceeding matter, my lord.
The respondent himself has died, sir.
Only legal
Yeah. What is this?
Yes, ma'am.
The present appeal, the delay is condoned. You say the present appeal is directed against an order dated 22nd July 2019, passed by the learned single judge, allowing writ petition civil. Sorry, disposing of writ petition civil 4582 of 2007, in which
next week, so I will
be order dated 3rd November 2006, passed by the Commandant Border Security Force bracket BSF, 27 Battalion bracket BN, dismissing the respondent from service, was challenged. Stop. One of the main grounds of challenge was that the dismissal order was in violation of the principles of national justice. Stop. Paragraph. However, during the pendency of the writ petition, the respondent died. So the learned single judge has found that the respondent was charged, the charge submitted against the respondent in the summary security force code was sought to be amended after the disposal of the summary proceedings. Stop. The learned single judge observed that the amended charge should have resulted in reopening of the trial. And instead, the appellate authority proceeded to confirm the dismissal order on the basis of the amended charge.
And sorry, my lord, may I interrupt, my lord? Yes, I'm sorry, my lord. Lordship may see the ground number VI and triple eight I BI triple I. Both the grounds are very important, my lord.
Sorry?
Lordship may see the grounds we have taken VI. May I read, my lord?
Yes.
The Honorable Single Judge has erroneously considered the dismissal order dated 3/11/2006 and under Annexure 15 passed by the disciplinary authority as summary security force court order, whereas this said order is the purpose of communicating the outcome of the SSF trial proceedings for the administrative purposes. But that next point I am coming, my lord.
The fact remains that he has died, sir.
Yes. Only point, yes. Only point is family approach.
Why should we interfere in these kind of cases? You see, considering the above factors and the fact that they in fact died, the learned single judge has, while setting aside the order of dismissal for violation of the mandatory provisions of the Border Security Force Act 1968, observed that there was no scope for redoing the entire proceedings. And therefore, there was no purpose in remanding the matter. Full stop. Accordingly, declared the disciplinary proceedings themselves as having abated and directed the release of the retirement and financial benefits to the family of the respondent. Paragraph. Having heard learned counsel of the parties, the court is not persuaded that any legal infirmity vitiates the impugned judgment of the learned single judge, warranting interference with this court. Also, for procedural illegalities, one possible course of action was for the learned single judge remanded the matter for redoing the entire disciplinary proceedings. Stop. With the respondent having expired that possibility did not exist. Full stop. It is in those circumstances that the learned single judge has proceeded to issue the directions as found in the impugned judgment. Full stop. The court finds no grounds made out for interference. The writ appeal is dismissed. The interim order is vacated.
And the next item is contempt, my lord. Let them.
The
contempt was in respect
petition
to
you say,
implement.
yeah, with the writ appeal having been dismissed today, the order of the learned single judge be implemented by the respondent contemners positively within a period of 3 months from today.
Okay.
The contempt petition is disposed of.
Oblige, man.
26. Item 26, I'm in VC, my lord. I'm for the appellant. Here the main question whether a society is needed to be registered under the EPF Act, my lord. Our basic stand here is, my lord, we have just employed about 6 persons. They are working on a basis in my organization. The society is almost about 70 years old. And
144. So 144 days delay, sir.
The president of the society is about 90 years old. We have also annexed a medical certificate in the delay application, my lord. And as on dates, he is about 92 years old, my lord. So that's because he was the main person in charge of the entire affairs of the society, my lord. And as on dates, he is about 92 years old and he is still alive. And this society is almost about 70 years old. And it's a very reputed organization. Destitute.
Right. Notice in the main appeal as well as the application for delay. Put down both writ appeal as well as the IA 849. We say notice returnable. 23rd.
Item 27.
27. State is the appellant, my lords. Lords, you may kindly have a glance at page 11, the impugned order dated 25th 19. The delay is very only total.
So your standards is very little.
No.
90 days only.
90 days. Now, let me tell one thing your lordship can dispose. The only thing is that the honorable single judge has said that you have not preferred any appeal against the judgment of the civil court. So, on the basis of that civil court judgment, the Tahsildar has rightly allowed the mutation. Now, the appeal has been preferred. Your lordship has only, I pray that subject to result of the
yeah, obviously. The judge has upheld the mutation since it was based on a decree of a civil court which had not been appealed against at the stage at which the writ petition was disposed of. Paragraph Mr. D.K. Monthil and AG now states that an appeal has been preferred against the said civil court's decree.
Right.
In that view of the matter, it is obvious that the mutation carried out will be subject to the outcome of the said appeal. Full stop. With the above clarification, the writ appeal is disposed of. Delay is condoned.
28 no instruction memo filed.
All right. Memos taken on record, disposed. No instruction.
29.
May I please, your lordship? My lord, there is a little delay, my lord. I have explained in annexure A by 1.
65 days.
What's the main matter about?
My lord, main matter, my lord, can I have a glance to the impugned order, running page 44, my lord. Learned single judge may permitted place.
Yes, please.
Learned counsel for the petitioner submit that this issue involved in this petition is similar to double petition number 4994 of 2008, which has been disposed of on 16/5/2019 by passing a reason order. Terms of the same, the petition may be disposed of. In this circumstance, this court interfering the order involving eviction of the petitioner.
By now, all this is over. Sir, 2019 matter.
My lord, here, my lord, the issue is
you were to only find out alternative quarters.
My lord, the petitioner in double petition number 944-4994 of 2018 are attached to the group center CRPF Bhubaneswar, my lord. But the present opposite party is not attached to the CRPF.
No. You were to shift him to an area once it is ready.
Yes, the petitioner in WPC 4994, they are attached to Group Center CRPF Bhubaneswar. But kindly have a glance to page 26.
What have you done, sir? This order was not stayed. This is the first day this writ appeal is coming up after 3 years.
My lord.
What has happened in the meanwhile?
My lord, in the petition, the respondent is occupying the quarter.
You could shift him, sir. The single judge gave you liberty to do that.
My lord, the quarter, those who are
they permitted you to allow him to for 3 months, and in the meanwhile take steps for getting new quarters in his hand fully ready.
Yes, my lord. New quarter were constructed, and the person, those who are attached to the Group Center CRPF Bhubaneswar, they were provided. But now the battalion number 39, 66, 43, 52, 149, no more attached to Group Center Bhubaneswar. The respondent belongs to battalion number 39, and it is coming under the Group Center CRPF Hyderabad. He will get a quarter at Hyderabad, my lord.
Then what's your problem? Why should we interfere then? He'll anyway go to Hyderabad, correct? He will anyway go to Hyderabad, sir.
Yes, my lord.
So what is your problem?
But he is not.
Then.
By
why interfere then?
By virtue of this order, my lord, he is not vacating my lord quarter.
If he doesn't report at Hyderabad, he'll dismiss him. No. Nobody can stay. When he himself is not in service, how will the family members stay?
Family occupying the quarter, my lord.
Why have you? When did he go to Hyderabad?
No. He posted at Chhattisgarh.
When did he go there? He must have reported in Chhattisgarh.
Person has reported that his place of posting.
His place of posting is, my lord, now at Chhattisgarh. But he is attached to Group Center CRPF Hyderabad. He will get a quarter at Hyderabad, not at Bhubaneswar.
Correct. So what's your problem then?
He is transferred to Chhattisgarh and now posted at Chhattisgarh.
So either way, sir, he's either in Chhattisgarh or in Hyderabad. He's no longer here.
He is not posted here, but he's occupying the quarter, my lord.
That is up to you. So if you don't know how to evict family members after a man has gone, don't come to the court for help. All this interim order, this is like an interim order. Just read your,
yes, my lord.
The judge permitted you to allow him to continue for 3 months, not more than that. Counsel for the appellant informs the court that since the passing of the impugned order of the learned single judge, the respondent has been posted at Hyderabad.
Attached to battalion 13 number.
He is attached to a battalion in Hyderabad, and so attached has now since been asked to report at Chhattisgarh. Full stop. Either way, he is no longer attached to the battalion at Bhubaneswar. Paragraph. In that view of the matter, the impugned order cannot come in the way of the appellant recovering the quarters in question, since the respondent is no longer attached to the battalion in Bhubaneswar. Full stop. Consequently, the appeal is disposed of.
God bless.
31.
None appears dismissed.
32.
None appears dismissed.
34.
It is 2J matter.
Where is it listed? The first batch which we had.
6 February.
List on this 6 February.
35.
May I please? Lordship, here the question of law is at page 9. A. Whether the Lord Sales Tax Tribunal as well as the fora below are justified in upholding the order of Association 42 of the OVAD Act passed by the Assistant Commissioner of Sales Tax Baleswar in Baleswar, who himself has approved the audit BDG, Your Lordship. Your Lordship, for A, I'm just placing, Your Lordship, can have a glance to assessment order. Audit BG report annexed 1 at page 19, Your Lordship.
Anyway, notice is not gone in this. This is the first time it's coming up.
Yes.
What's the tax effect here?
It's 60 some lakhs has been demanded.
I see. All right. Notice, he accepts notice. 24th April.
My lord, IA.
What's the IAS notice on that? All right. Okay. Yes.
36.
My lord, in item 36, Honorable Justice Raman was the representing state before the Honorable Tribunal. However, I have no hesitation if my lord take up the matter, my lord.
So this is a fresh matter or what?
It's a fresh matter, my lord. My lord, the demand has been raised on 2 occasions, your lordships. That although the petitioner deposited an amount.
You were the consul there. That's all. I know. But still, it's okay. List before a bench of Justice Raman is not a bench. On 30th January.
37.
Obligement.
Let's be a Friday. 27 January. All right.
Yes. Yes, sir. Prayer of the petitioner in this case, restoring the matter to file below, save appeal application. The reasons I have given in para 3, 4, and 5 below.
All right. For the reasons stated there in that order is recalled. And petition civil 2220/2022 is restored to file. So what's the main?
This is the matter where the petitioner challenged the order passed by the appellate advance ruling authority. Where the initial advance ruling rendered by the advance ruling authority by annexure 1 in favor of the petitioner. The question is, I was running a chain of bakery unit millers. And the question arose whether I wanted a regulation by way of advance ruling, whether it's coming at a restaurant.
No. So they hadn't filed a counter. The counter
region are all of 5 minutes.
You just say list for final hearing on 10th April.
But I pray for stay of annexure 8 minutes.
No stays at any point. There was no stay. No problem. Yes.
38.
Yes.
Hello, I filed.
May I please, your lords?
Yes.
My lord, the opposite party number 4 forcefully constructed a house over the government land, that is Jalasoy, my lords. The petitioner facing problem for communication. My representation annexure 2, my lords.
Petitioner's representation bracket annexure 2 shall be examined by the Tahsildar.
Yes, my lord.
Anandapur, and after notice to the petitioner as well as opposite party number 4. And a reasoned order shall be passed. Not later than 13th February.
Yes, obliged.
And communicating the parties within a week.
My lord, may kindly write Mr. Nikhil Pratap in council.
Hi, sir.
He is appearing for the court.
All right. It's a privilege. All right.
Nikhil Pratap.
All right.
Obliged.
39.
My lord, appearing virtually, my lord. My lord, in similar matter, your lordship have already issued notice on the writ petition, also on stay. My lord, my colleague is there in the court. That place before your lordship. This is a case, my lord, to circular issued by the CBIC is under challenge on the ground that it is ultra virus of section 4B of section 73. Section 4B of section 73, my lord, it says that the adjudication is to be completed within a period of 1 year maximum. Whereas circular provides that the...
What date is it coming up? Which date is the connected matter coming up?
My lord, date is not there. Kindly see the order, your lordship.
All right. You just say notice, Mr. Chaudhary, Satyajit Mishra accepts notice. Mr. 1 and 2. Replies be filed within 8 weeks. Rejoined for the
I've already filed my counter.
List along with writ petition civil 28599 of 2021 on
In this case, department has already filed the counter.
Filed, I will stay.
Stop the copy also.
It's okay.
My lord, what is the date, your lordship? Sorry, my lord.
Sir,
my lord, next date.
Date loudly.
25th April. I don't know, 40.
May I please? My lord, the petitioner grievance is that his appeal, my lord, filed under GST Act rejected for non-submission of certified copy, my lord. In fact, the assessee submitted the hard copy after the notice. And
Who's
in
for the other side?
My lord, I'm not.
You want to take instructions?
Yes, my lord.
Or
But Annexure 3, my lord, can see page 17 of the petition, writ petition, where it has been pointed out by the authority that he has not submitted the copies.
okay. So what we prepared to submit it now? Let it go back, sir.
Yes, judgment already in similar matter already passed.
Kindly send someone to collect it.
Atlas PVC.
No. This is something else. What are you showing?
Para 8, my lord.
He's in item 40, sir. Yeah, same thing. All right. The only reason for rejecting the petitioner's appeal was the non-filing of certified copy of the order and appeal. Full stop. Having heard learned counsel of the parties, the court condones the delay in filing the certified copy and sets aside the impugned order dated 19th August 2022. The certified copy now shall be submitted.
Already applied, my lord. Already applied as per instruction has already applied, and in the meantime maybe we should get the certified.
And you will give it the certified copy, sir. Without that, you can't have the impugned order set. I thought you already
Within
got
10
it.
days, time maybe allowed 10 days from today.
In that case, just take out the order. Counsel for the petitioner states that in 10 days' time, the certified copy of the order of the Joint Commissioner. Whose order, sir? Joint Commissioner.
OP number 1, my lord.
Of the CT and GST officer Kyonjar will be made available. List on.
There is another read same different period, my lord. December, that is 31057, not on the list.
Whenever it comes, we'll see.
41.
That will show me that.
Please, Your Lordship. 41 and 42.
Same
Similar
order.
matters are yes, not.
When is it
And
coming up?
posted to the 23rd of the February. Lordships have fixed all the matters. Similar
23rd
matters.
February.
May I submit? I want to
And
submit.
Lordships have granted a notice and a stay has been granted. No coercive action.
I may be permitted to submit something.
Here, Lord, I have challenged the fixation of excise duty of the year 1617 after annexure to Lordship and glance.
1 minute, sir. He wants to say something. Yes.
This is a demand notice on the basis of the AG audit report. And your Lordship has already disposed of many cases. In case of AG audit report, this demand notice will be treated as a notice, and he will be filing so cause before the government, and government will take a decision whether this demand is, because this demand has been issued by the district excise office of the respective districts. And similar, it is a fact that in one case, my lord, the Honorable Court Number 3 has issued notice. That is why he is saying that it should. But similar type of cases, your Lordship has disposed of, directing the secretary to take a decision and giving liberty to the petitioners to file their objections to this AG audit report. And at least I think Mr. Patra's case, 30 to 40 cases.
The government order has not been challenged. You have challenged the government order. After 5 years,
that is why government is directed. Since it is a government order,
they have revised demand notice. And out of revised demand notice, Lord, 5 persons have been granted stay. Serial number and 6 and 7, they are item 41 and 42. All the Lord in the revised demand notice, the pending for adjudication 23rd February. And Lordship to file counter to them and for rejoinder and for hearing on that day.
What he is saying, I don't dispute it. When the matter was posted before the Honorable.
Can they fix him?
Just a minute, just allow me to speak.
16, 17, they are fixing.
I am not on the merit of the case.
7, 20, 21. Yes.
I am not on the merit of the case. It is my learned friend is saying.
This court has entertained and notice has been issued and you have been directed to file counter. You have not filed counter as yet. other cases.
That is what I want to submit before the Lordship, so that the matter can be once tested by the government, that whether the claim raised by the district excise office is correct or not. And similar type, I can provide similar cases, type of cases on AG audit report that your Lordship is remanding.
Here, one case is Secretary has said that I cannot decide my decision because it is the decision of the government. 8/7/2020.
All right, notice returnable 23rd February. Mr. Mohanty accepts notice. Reply be filed within 4 weeks, rejoined up for the next date. In the meanwhile, no coercive steps shall be taken against the petitioner. List along with writ petition civil 6501 of 2022. All right.
Same demand notice. Item 42.
43.
43.
This Ayurvedic, I'm sorry, I don't have the old brief to look at the file. But
dismiss it. Whenever you locate it, you can revive it. Counsel for the petitioner states he is unable to locate the file. The petition is dismissed for non-prosecution with liberty to the petitioner to revive it as and when the file is able to be located. All right.
45.
44 is over.
May I please your Lord?
Mr. Miller, the opposite party has died. I will have to file a substitution petition. For that reason, I want some time, Miller.
You're for whom?
Opposite party, Miller.
No. Who's for the appellant?
My Lord, I am appearing for the appellant.
What is the matter about?
No, there is a...
What's the delay?
Delay of 9 days, my Lord.
Or the delay is condoned, that is disposed of. What's the main matter about?
My Lord, in this case, if your Lordship will come to page 8 of the brief.
Yes.
Para 7. That two questions of law have been framed. Whether the Lord Sestat has jurisdiction to decide the ownership of the seized gold between two private parties for which national civil court is the proper forum to decide the matter. The next is whether the Lord Sestat is correct in allowing the appeal filed by the present respondent when the Lord Sestat by order dated 11/10/94 had upheld the order of the adjudication authority passed in the case of Sri D. Janardhan Swami, and the said order has not been challenged in the higher appellate forum, and thus the said order attained finality and question of reopening the matter does not arise. In this
so when did this respondent die?
In Corona period, 2020, Your Lordship.
You have a date.
31st August 2000. Sorry. 6/7/2020.
Counsel, the respondent states the respondent expired on 6th July.
6th July. 6th July 2020. Your Lordship.
Steps be taken to bring his LAS on record. List on 25th April.
46.
Wait, please, Your Lordship. My Lord, I'm constrained to say, my Lord, no instruction in the matter. Lordship may dispose.
Not rare, Your Lordship. Though Your Lordship has condoned the delay, a copy may can.
My only counsel for the petitioner states there are no instructions.
Lordship gives me the liberty to come back, my Lord. Like, my Lord, in the last batch, because this is that NCLT related issues, my Lord.
Or you say if there's any fresh cause of action to be open to the petitioner to seek appropriate remedies. All right.
I'm obliged.
46 to
52, my Lord.
53.
All the Balakpur.
52, correct.
Obliged.
I'm obliged to 52. All right.
53.
53, my Lord, revenue implication is low.
So the effect is low, the question law is left open. Petition is disposed of.
54.
54, my Lord, the question of law is at page 22.
But steps regarding limitation not taken, sir. So 54, what the limitation?
As per my instruction, it is in time, my Lord. The revision.
54 days.
What's the question of law, sir?
Question of law is at page 22, my Lord. number 1, whether on the facts and in the circumstances of the case, the order of the Odisha Sales Tax Tribunal.
What's the tax effect here?
Tax effect is ₹1 crore.
All right, notice on delay and revision petition. Returnable 25th April. Right.
55.
None appears dismissed.
56.
This is 2J matter, my lord. 56.
Same.
57.
Lordship, 57, I'll remove the defects. The IA number 198 of 2018 is for dispensing of
All right,
certified
that's allowed.
copies.
All right. Defects we removed within a week. This thing. Not
58.
58, Lordship, kindly taken up next week, Lordship. This brief is transferred to us today, Lordship.
All right. At the request of counsel, the petitioner list on. 7th February.
59.
59, my lord. It is covered, my lord's judgment at Chandrakanta Jewelers case. 42.5 penalty, my lord.
What's the delay?
10 days.
Delay is condoned. Notice returnable 25th April.
60.
May I please, my lords? My lords, the learned tribunal has remanded the matter to the first appellate authority with a limited scope, my lords. Though I have filed number of C forms before the appellate authority, it was misplaced by them, my lords. Then I produced duplicates. But learned tribunal has allowed only 1 C forms. My lords, let me raise all the issues, my lord. Let me open remand, my lords. Otherwise, I will be prejudiced, my lords. Tax effect is 12 lakhs, my lords. And availability exemption under the IPR also effective.
No instructions copy has not been solved on us.
Oh, I see. Notice. All right. Yes. 26th April.
61.
My lord, appearing for the petitioner, my lord. There are 2 defects, my lord. If I may be given 1 week's time, my lord, I will remove the defect, lordship.
Defects we removed within a week, less than out.
Obliged, my lord.
62. Lord, 62, my lord, I need to substitution because the petition expired on, my lord, 22/2021, my lord. 22/2021, my lord. Yesterday night, my lord, I give the information. So I need the substitution petition to be filed.
At the request of counsel, the petitioner list on. 6th March.
63.
63, your lordship. The both are the similar, my lord. Here the question of law is not, lordship, see page.
IA is allowed. In
8.
both matters, IA is allowed.
Page 8. Here the question is, my lord, the investigation unit, my lord, search a person, and basing on their statement, my lord, demand has been raised, my lord. And
He accepts notice. Both matters.
Yes.
64.
Both matters, 63 and 64, same order.
67.
65.
Make this Lord. And I beg the PML to the the state had taken the short point is on 30th May 2000.
So today there's a Mr. Vaidyanathan, today there's a reference at 2 o'clock. So we may not be able to take it up today.
Very good.
So we'll have to adjourn it to some other day.
Consider taking it up tomorrow.
No, we don't know when references will happen here.
Whatever.
So,
my lord, may keep it next Friday.
Next.
Whatever is the earliest date.
It'll have to go to next year. It's possible to have it earlier.
Next Friday.
The problem is the petition is in deep financial trouble.
I know, but
181 crore has
but
been for
each High Court bar has its own traditions, sir. So this is another thing. So
whatever is the earliest date.
Right. 6th March, sir. 6th March. Right. Right.
Would it be sometime in January?
We can't, even if I give a date on that day, if there's a reference, again, we'll be in the same position, sir. So
we'll try on
it'll be
next
difficult.
Can we take a chance?
No, actually, I've got a whole list of things here. It's all going all right.
I follow. I was only wondering we can take a chance in January some date.
No, January is certainly ruled out. I can probably accommodate in sometime in February. You could take a chance on 14th February.
Very well.
14th February. All right.
Very well. Grateful.
All right.
Grateful.
Grateful.
66.
And also, all the said matters are posted to 7th of December at 2 p.m.
The lead matter is posted to 2 p.m. on 7th of December.
All right, 7th December. All right.
My Lord, kindly one thing. In pursuance of the last order, we have already filed the affidavit of IGR that is on record. Hard copy also I am filing. And I have also given a copy to Mr. Agarwal.
All right, let's see that.
In 66, in the lead matter, we are filing on behalf of the OP number 5, a counter and a convenience note. That may also be taken on record.
All right.
Copy that again.
I would request a copy may kindly be served upon us.
We'll solve.
Lord, I have a prayer. This 66.
All right. The IGR has filed an affidavit, which is taken
Lord, I
on
have a
record.
prayer, my Lord.
Opposite party number 5 in
Writ petition number 18799.
799 is also filed an affidavit, which is taken on record. All right.
A note also I have given regarding that issue.
Affidavit and note, both of which are
Lord, I have a prayer. Lord, one. Lord, there are several IAs. I am in fact, my Lord, appearing in one of the interim applications. Lord, that is 8021 of 2022. Lord, several applications your Lordship knows have been filed for intervention. Lord, it appears from the record that those intervention applications have not been allowed. The difficulty is that if the parties are exchanging affidavits, we are not legally entitled to any one of it. I am from, remember, it is benefit for both the parties, both promoter and the alert. I am for the.
I can permit all of you to take a soft copy.
So, no, Lord, the right to be heard, your Lordship knows that unless
that will not
is allowed.
Yeah.
So I can't have a chance to file a counter review. So that is the problem. So this IA number, I don't think that my learned friends would oppose it. The 8021, that is for the association of the promoters of the states. Lord, we are not concerned with any.
We'll just take it up all on 7th, is it?
7th.
That's not far away. 7th. 7th is only day after tomorrow.
Lord,
list on 7th.
At PM it was fixed.
All right. Subject to, of course.
My Lord, yes.
Yes. All right.
67.
Malad, on behalf of Mr. Zena, kindly give me 3 days for remove the defect, Malad.
No, this is not defects. 67.
Yes, Malad.
67
it's not
19771.
I have not filed the requisites.
Case number. এই দেখ না 67
বংশীধর প্রধান বংশীধর প্রধান
বংশীধর পাত্র
হ্যাঁ 67 ঠিক আছে
fresh notice returnable 26th April. All right. Well, fresh notice on the unserved. You say fresh notice to opposite party number 4.
Yes.
Returnable 26th April. All right.
68.
জানি পারলেন জানুয়ারি
Who's in 68?
68.
68. So kindly permit to withdraw.
Council better seeks leave to withdraw the presentation dismisses. All right.
69. 69, my lord, I have already served copies and I am appearing in person, and I have also filed petitions, representations by Annexer 1 and 2, page 9 and 10 of the writ petition. Notice may kindly be issued.
So what is this filling up the vacancy of member OHRC?
The vacancy, the member demitted office, my lords, on 21st of August.
And 4 months away. How come for 4 months you haven't appointed?
This judgment of the Supreme Court.
It's a notice, he accepts notice.
Who will obtain instructions?
He seeks time for instructions. List on, we'll have it at this end itself. List on 19th December.
All right. 70.
May it please, Lord. My lord, I'm in busy mode. My lord, here the challenge is under Annexure 4, my lord. That the cancellation of my registration without giving me hearing.
2019. Cancellation.
And
no, 2021, 26/11/21, sir.
My lord, my appeal was rejected on the ground of
26/11/21.
Yes, my lord. 26.
You ask him. Whatever you say, sir, you ask him. Ask him. Why did you ask him?
So, counsel, within time, he has not approached this writ court.
My lord, as this person got that appellate order, the letter, my lord, and they have not communicated anything to this petitioner, but later he got that from the website. And after getting that from the website, my lord, he has to approach this. And that order was also passed in absence of the petition without giving an opportunity hearing, my lord. And their cancellation, your lordship, first this person was filing return under the VAT. But after GST come, my lord, he faced trouble to file that return. And for non-filing of that return,
have you explained anything in your writ petition?
My lord, I have taken that, my lord. Your lordship, my grounds are there, my lord. 8B, my lord. For that, the petitioner was never issued any notice physically or intimated over phone before cancellation of the registration, as Section 29 of the OGST Act provided that before cancellation of the registration of a person, sufficient opportunity of being had to be given. But in the present case, no such opportunity is given to the petitioner. Corresponding to Rule 22 of the OGST rules, also provide for giving opportunity of a hearing to the person, and a reply found to be satisfactory, the proceeding be dropped. Though the petitioner has filed the satisfactory reply, but the same was not considered and his registration was cancelled. The appeal of the petitioner was also dealt in a mechanical manner.
Mr. Counsel, I have asked you the question that after receipt of first appellate order, why have you delayed in approaching this report? Have you stated any explanation in your petition?
For approaching this honorable court, my lord. My lord, I have got that order was, my lord, passed on 21, but I got that in 22, my lord. After getting the same, I have filed.
When have you received it?
My lord, I have received in 22.
When did you come to know?
My lord, after checking that from the website, my lord. They have not intimated me anything in black and blue.
No. What is the date, sir?
My lord, that date I will Lord, ask him.
Right. After of the order is uploaded immediately in the portal.
That is on 26/11/2021, your lordship, that order, that appellate court order.
Yes.
And I got that in 22. That on verification, I got that because nothing was communicated to me regarding that cancellation, nor any my lord, rejection of appeal also communicated to me.
Late instructions, my lord, whether any.
All right. Counsel for the state requires time for instructions. List on 20th February.
Right.
71.
Your Lordship, petitioner in this case prays for grant of refund flowing from the order of assessment dated 28/2018. There was an excess payment of 50 lakh rupees. Your Lordship,
There's a procedure for applying for refund, isn't it?
yes, Your Lordship. Your Lordship will find it at Annexure 2, Your Lordship, page 37. Immediately after receiving the order of assessment on 28/2018, I have made an application on 23rd August 2018.
You want to take instructions on this also?
Copy not served, my lord.
All right. Counsel for the state requests time for instructions. List on 21st February.
72.
Please, Lord. 2 weeks time grant for defect removed.
All right.
I don't
Defects
know.
be removed within 2 weeks. List thereafter.
73.
73, my lord, appeal lied to the GST tribunal and I have paid all the taxes.
All right. The GST tribunal not having been set up yet, the court is constrained to entertain the writ petition. It's a notice returnable. 27th April. Replies be filed within 4 weeks, rejoined up to the next date. Defects be cured in the meanwhile. In the IA, you say counsel for the petitioner states that the entire demand has already been paid. In that view of the matter, till the next date, no coercive steps will be taken. All right.
74, my lord, same order may be passed.
Same order in 74.
Obliged, my lord.
All right.
75.
75, 1 week time, my lord, remove the defect.
All right. Defects be removed within a week. List thereafter.
76.
76, my lord, in this case, already this point of law has already been discussed by this honorable court and kindly
just all right. Same order.
$77.
May it please your lordships. My lords, they have submitted the affidavit in compliance with the order 672022. And their admission has made my task very easy. And they have stated in para 4 that I have been.
We have solved the copy. Today we are filing the counter affidavit.
Yes, counter affidavit. You have solved the affidavit. I don't want to file the counter affidavit. I don't want.
Where is the
You have para 6.
We have not seen the affidavit, sir.
My lord, today we are filing.
If
say kotha kahuchi pura.
Oh, no, I perhaps I was hard. No, it is good because now it is also marriage season, reception season. And every day I see in my residence 4 to 5 cards. Tiku words, Niku. Then my lords to 2 words. And every day, my lords, after going to the reception, I find that stomach ache. So, my lords.
All right. You see, the affidavit, counsel the state says he'll be filing the affidavit pursuant to the order dated 6 July 2022 during the course of the day.
Yeah.
A copy has been served on counsel to the petition.
Para 6, they have already admitted that I have been earlier assessed in Borgad.
Okay.
Now the Balesur Circle is assessed.
Oh.
So no tax has been paid.
No tax. You have already assessed. I have paid the tax there. How can you know? Then you bring another affidavit.
All right. List on 21st February.
21st February, my lords.
78.
78, my lords.
30,000 some odd, my lord. 30,000 कितने अच्छी?
Kuda.
78.
78 and other matters, my lords. We reference, my lords. Lords, you may take up this after New Year.
Right.
And my lords
But
have
we have not.
fixed under.
This notice has been issued already. All right.
My lord.
Yes, yes. And interim stay I have got.
No wonder.
Only it has to be made absolute.
All right. List on 2nd March. Interim orders made absolute that case is disposed of. All right. Which is this and which are the matters, sir?
83, my lords. 83 that 83.
78 and 83.
Yes, yes. That Biswas se Vivad scheme. And my learned friend is appearing, Siddharth Mahapatra. And he was supposed to give an affidavit. Then, my lords, 86, that too much of natural justice. It was hard on last Thursday. Notice after notice. Notice under section 148B is to be given only once.
What we'll do is just call out one by one, sir, because it might get confusing.
Sorry, my lords. 83, then 6.
No, just wait for a minute, sir.
Yes, yes.
We'll just call
Sorry,
it.
sir. Yes, ma'am.
77 is done.
Yes.
78, sorry. 78 is done. What about 79?
79.
My lord, appealing for 79, my lord. Respondent.
And only the question of law is framed.
My lord, the STCs are also in appeal. The STCs are also in appeal, my lord. If you lordship would take the first two matters.
There's no time, sir, today. It's just 79.
No, I'm not submitting. I say that this matter may be tagged together. STCs are also in appeal against the same bill order.
All right. Give us the numbers, sir.
My lord, the appeal number in the first case, your lordship, Rungta Mines Limited, is your lordship 9 by 2016. Sorry, 3 by 2021. 3 by 2021. And in the other case, my lord, Rungta Sons Private Limited, the appeal number is 2 by 2020.
All right. List along with OT APL 2 of 2020 and 3 of 2021
My lord.
on 27 March. All.
Your lordship, may I submit something, your lordship? In sub-item 3 in this item 79, the petitioner, the opposite party has expired last year. So I may be allowed to file a substitution.
So nobody will prevent you, sir. I can assure you that if you file an application for substitution, no court will prevent you from doing that. All right.
Okay. I just wanted to let.
No. Fine. Fine.
80. Appearing for appeal number 11, OT appeal number 11.
Right.
For
All right. Sub-item on 4 and 5.
All right, sir.
Recusal is filed. No notice. No question is framed, my lord.
It will all be done next time, sir.
Item 80.
My lord, this case may be taken up any other state because
Lordship, in this case, Honorable Court has directed to the state government to formulate one policy on 15th September, and Lordship has given 2 months time. Lordship, till date, they have not taken any step to formulate the policy, Lordship. The Lordship see the casual
time frame
attitude of the state government, Lordship. And they are demolishing the ponds, Lordship. Not filing any counter to the case. It is the livelihood of the people of across Chilka, Lordship.
9 January, sir.
9 January.
2 p.m.
Second,
Lordship,
2 p.m.
My lord, interim order may
Interim order to be
Interim order.
interim
9 January.
9 January.
Thank
You see, on account of there being a reference today, 2 p.m. The court is not in a position to take up this case today. List on 9 January at 2 p.m.
My lord, may kindly note we have filed 3 affidavits today. That may
in this matter, this item number 80 may just request your lordship.
My appearance may also be noted.
Sure, sir. Sure.
Lord, in item number 80, I have a small prayer to your lordship. Lord, I am here, my lord. I am here. In fact, in view of the rush there, I have come to this side.
Yes.
Lord, here in this matter, I have filed one IA flag 200, my lord. Lord, since 9th is the date fixed by your Lordship, Lord, I would not have any grievance. But 9th I'll be absent because I'll have to go to inspect those schools. I have fixed those dates.
Right.
Lord, in fact, that's the reason I request, Lord.
All right.
Like 200, man. 210.
Then it will have to be 16 January, sir.
Let it be.
6.
The interim order to continue, Lordship.
Yes, sir, we have already said it.
81.
My lord, ready for final disposal because they are proposed to acquire the land of the tribal peoples. So that's why it is ready for final disposal and 20th March.
20th.
Interim order to continue. Interim order.
My lord, a short date may be fixed because it's a government land stay order is there. January.
Which one is this? This is that
81. For whom Mr. Mohanty is.
Any date, my lord. All right. 13th February.
Oh, please.
82.
82, my lord. 2 days time may be given to file the consolidated writ petition, my lord. And we have already prepared, my lord, 2 days time to.
All right. Consolidated writ petition to be filed.
Well, item 82, I am appearing for the opposite party number 9. Well, as it appears from the noting that the counter affidavit has been filed by the OP 1, 2, and 10.
Yes, ma'am.
Well, a copy of the counter be served.
Copies of the counter of other parties be served and counsel appearing for opposite party number 9. All right. List on.
Oh, bless.
84.
Madam Lord, have received the counter. The Lordship may kindly grant me some time for a rejoinder.
Rejoinder to be filed for the next date. Interim order to continue. List on 29th March.
29th February.
March.
Interim order to continue. Lordship have kept it to 29th of January.
29th March, sir.
March. Much obliged.
Please call out 83.
83.
83, my lords, that
83, my lord.
Lordship directed the department to take.
I'll file an affidavit in reply. Only kindly be taken up 15 days.
All right. Counsel for the department states that he will file his reply. That's already there, sir.
No, reply, my lord, preliminary reply was filed prior to disposal. That this was disposed of and thereafter it was recalled. Then I have to file a.
Seeks and is permitted to file a further affidavit. Within 4 weeks, rejoinder for the next date. Interim order to continue. 29th March.
Very good. Interim order to continue, my lords.
I've just said that.
85.
My lord, similar matter has been posted to the month of February. 49th March 2022. That is a question of jurisdictional issues, my lord.
This case covers, my lord, the case, the batch of order your lordship passed in AD. That covers. Only in addition to that, my lord senior is submitting that is change of jurisdiction. Jurisdiction, my lord, is in common. Yes, my lord, that may be raised.
You can raise that also, sir.
Because for all jurisdictions,
all those questions you can raise.
My lord, that is a jurisdictional issue. That is the assessee belongs to Berhampur. Without his jurisdiction, he got a notice from the Sambalpur for which he has filed before this court, and this is covered by the decision of Allahabad High Court, my lord.
No, my lord,
also giving that
change totally.
Counter, agenda, everything has been filed.
That has been shifted to the DCIT Sambalpur. So, my lord, when the area is changed, for all, my lord, there is no necessity of issuing individual notices.
I giving the decision to Allahabad in that point of.
Also, all this you can urge this also, sir.
So this matter fixed for 29th March, my lord. Similar matter. So 29th March.
That day will follow today's order, sir. That's the best. You say the present petition is already covered by the order dated. Give us the date of the order, sir.
That is, my lord, on sorry, right.
It's already uploaded. You must already have a copy of the order, sir.
Yes, ma'am. Friday, my lord. I'm supplying. Your order, common order.
Our order, sir. What's the date
I'm
of
giving, my lord, on Friday. That was on last Friday.
All right. Order dated.
Sorry, my lord.
Not Friday. Can't be Friday. Must be Thursday.
Oh, sorry, Thursday.
Order dated 1st December 2020. Sir, kindly keep a printout of that order ready in court.
I'm supplying just.
There will be similar matters. Yes. So the order we passed on 1st December in the big batch of income tax matters. Kindly keep a printout of that order in court. This matter is covered by the order dated 1st December 2022. Passed by this court, permitting the petitioner to raise all pleas as permitted in the said order, including any other plea that the petitioner may have on the issue of jurisdiction. At the appropriate stage, the petition is disposed of. Interim order is vacated.
86.
My lord, I could have verified whether it is covered or not because
we'll do it for you. So we have done it for you. You do it at your leisure, no problem. Right.
86, my lords. On the other day, lordship segregated this matter, my lords. And the whole question is whether the assessing officer is empowered to issue so-cause notice after so-cause notice. So therefore, the matter I have to address at least 1 hour. At least 1 hour, my lords. So therefore, lordship may keep it to next week or any day as per your lordship's convenience. It is just like, my lords, repentation will not extend the period of limitation. Your lordship have several judgments your lordship have rendered. Repentation will not dispose.
Instruction here?
My lord, the instruction I'll file in reply, a short reply, but here that can be because Act doesn't preclude, my lord, the department to pass orders subsequently, my lord.
And Act permits the assessing officer to repeat after repeat.
Also, extension of time
Yes.
at the behest of the petitioner has been given.
No.
Yes, my lord.
You could have refused it.
Counsel, the department wants to file a reply. Reply be filed within 2 weeks.
Statutory cannot be extended.
List on 3rd January. In order to continue. All right.
Balance. Much obliged.
87.
Our second list.
Petitioner's grievance has already been complied, madam.
All right. Counsel, the petitioner says the petition has been rendered infructuous since the petitioner's grievance has already been taken care of.
My lord, I'm appearing
Petition
from
is
opposite
disposed
party
of.
number 1 to 3.
All right, sir.
88.
88, but I'm filing rejoinder today.
All right.
There is a
My lord, what I suggest in this case, my lord, they have challenged the order of the collector shifting and status quo order has been passed. By extending the status quo order for further period of 4 months or 3 months, your lordship can die because that is an appealable.
No. Here, this theory of appeal cannot be placed into service because my learned friend is suggesting to go in appeal before the commissioner. Commissioner is the approving authority here. So appeal theory will not do it.
All right. So rejoinder is taken on record, interim order to continue. List on 4th January.
Yes, interim order to continue.
I've said that.
90.
90, your lordship have formulated a question of law.
All right. Say list for final hearing on. We'll have it on for the day. 29th March.
Special notice. 1. I don't know 1.
Yes, my lord. We have already prepared, got the instruction, we'll be filing the counter affidavit within 10 days. Last chance, your lordship, peremptory orders.
Mr. Mohanty states that as a last chance, that he'll positively file the affidavit on or before 1st February 2023. List on 16th February. No, list on 21st February.
21st February.